Good call, Bruce.
Okay, call meeting to order at 5 o'clock. Everybody stand for the Pledge of Allegiance. Pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, Alicia, you want to do roll call, please?
You bet. Steve Dagalow.
Here.
Corey Miller.
Here.
Ian McDonald.
Here.
Lori Blargen. Here. Bruce Blargen.
Here.
Danny Erickson. Here. Matt Fugall.
Here. All right, our district mission: together we engage, educate, and empower all learners, bridging their passions to pathways to create successful futures and positively contribute to our local and global communities. Is there a motion to approve the agenda?
So moved.
Is there a second?
Second.
Any discussion? All right, all those in favor?
Aye.
Any opposed? All right, motion carries. Next item is public comment. No one here, so we'll move into item 3. Trevor, for roles and responsibilities, there's a PowerPoint I just emailed everybody right before the meeting. If anybody wants to follow on their computer, otherwise I'll have it up there, but.
Do you want me here, there?
I think so this is what it,
Okay, so maybe I'll stay here.
more up.
Yeah,
Yeah, perfect.
Evening, everybody. Corey, I don't think we've met. I think I've met everybody else. My name's Trevor Helmers. I'm an attorney with the law firm of Squires, Waldsberger, and Mace in Minneapolis. I have probably, I think, trying to see who would be the longest tenured. I think I've been the attorney for Somerset for maybe 12 to 15 years. That sounds right to anybody. I don't know if everybody's been here as long as I've been here, but so just a little bit of background on who I am and what I do. I only represent school districts and then other governmental entities. So being a school lawyer is kind of all I do all day, every day. And that includes a lot of things that you wouldn't necessarily even think of. So as a school lawyer, kind of the areas that I practice in are things like employment law. You're often the biggest employers in a town. It would be special education law. It'd be student issues. It'd be writing contracts. You've got Market and Johnson out here doing construction. It's doing all those contracts. And one of the big things as well is working with school boards. Because when I am hired by a school district, I am the board's attorney. I don't represent the administration. I generally work with administration, but I represent you, the board. And so this whole presentation that I put together and that when I do these trainings for boards, you know, it really is kind of putting it together so that it's helpful for you guys. So it answers a lot of the questions that you might have immediately off the bat. And then it talks about a lot of the, you know, other things that you should be aware of. However, listening to me talk for a straight hour would be very difficult and boring for you. So if you've got questions, if you want to talk about something in more depth, if you say, hey, you know, I had a situation like that, I want you to stop me and I want you to go ahead and ask me because I want to be able to answer some questions too and make this as helpful as possible. So starting out, talking a little bit about obligations of board members, there are a couple of obligations that are outlined in state statute, including that each board member has to take an oath to support the constitutions of the state of Wisconsin and the United States. And then we have a state statute that requires you to perform your duties to the best of your abilities, to not engage in any act forbidden by law, and to faithfully perform your duties. And really when we talk about board obligations, one of the things you have to remember is you also have what's known as a fiduciary obligation. That you essentially owe a duty of loyalty to the district over private interest, and you have to avoid any conflicts of interest. I'm going to talk about that a lot later. We've got a lot of materials in there as well. But really that talks about you can't have a financial interest. You have to have the district's interest kind of first. Your financial interest can't potentially get in the way of that. And when we talk about school boards, you guys have a really unique function because you do a lot of different things, including you serve in a quasi-legislative role when you adopt policies and budgets. You're in a quasi-judicial role. If you're holding an expulsion hearing for a student, you're essentially serving as a judge there. And then you also have a quasi-executive role in hiring and supervising and evaluating the superintendent. So when you're talking about board, the vast majority of your stuff, the vast majority is legislative. You guys are the forward-looking body that's making all the plans, all the policies for the district. And then generally you give it to the executive to run. And so you really have all three of those roles though, which is really unique, you know, and it kind of encompasses a lot, that you guys are responsible for a lot of stuff. And one of the biggest and most important things for board members to know, and I also think this is evergreen, I give this speech all the time to people who have heard it before and they say, you know, I feel like I catch something new every time. Because the open meeting law is so important, and it's something that you guys deal with every time you meet. And so it's really important to get into some of these deals and talking about the open meeting law, because public policy, state of Wisconsin, is that government in the sunshine. When we are going to act as a governmental entity, it's going to be in public. Everybody gets to come in and watch us. Everybody gets to see our discussion. Everybody gets to see our votes, unless an exception applies. But in general, you should know that everything you do is public. Anybody off the street gets to watch everything you guys do as a body here. And it kind of brings up the next question then, and one of the issues become, when does this apply? Well, the open meeting law applies every time that you have a meeting. And a meeting is defined as the convening of members of a governmental body for the purpose of exercising the responsibilities, authority, power, or duties delegated to the body. Which, as you might be able to tell just from reading that yourself, what does that mean? It's not exactly clear. That's incredibly broad. So we have judicial interpretations, and we have courts that have looked at this over and over again, and what they have essentially said is that you are having a meeting of this board whenever the members convene to conduct governmental business and a sufficient number of members are present to determine the body's course of action. So essentially what that means, and it doesn't really matter what you call it. That's the other important point here. When we're talking about is it a meeting, we don't really care what you called it. We look at the conduct. We look at what happened during that interaction. And if you call it a work session, if you call it a conference, if you call it an interview, it doesn't really matter. Ultimately, you have to look at the governmental business piece and are there sufficient members. And so on the governmental business piece, courts have held that governmental business includes discussion, decision, and information gathering. Thus, a meeting can occur if members gather simply to listen to facts or statements from someone else. And the sufficient number in general, in most cases, what we're talking about is it is a meeting if you have a quorum or more of the board. Because a quorum or more of the board, they're the ones that can have decision-making authority. They can decide an issue. And so if you think about taking this to, to kind of understanding how it might work in practice, one of the examples that I have in your materials is that going to another body's meeting, a quorum of you going to another body's meeting is a public meeting. Say that 4 of you wanted to go to a village meeting, village council meeting, and you wanted to hear something that they were talking about a road decision because it was going to impact our construction here. If a quorum of you went to that meeting, that is technically a meeting of this body, a meeting of the school board. So yeah, of course they're noticing their village meeting, but you would also have to notice that you were having a public meeting of this school board there that night. So it can happen even in that situation where you're going to another body's meeting. It's not your body's meeting, but because you are receiving information that is potentially going to inform a decision that you're making down the road, then that would be considered a meeting.
Trevor, can I ask you a question?
Of course.
Are you going to talk about closed sessions in this?
Yeah.
Okay,
Yep.
great. Yeah, my question about closed session is how we record that.
Yep.
Because there should be some recording, right? I mean, whether it's handwritten notes or something to that effect, or discussions and voting, how does that work?
Yeah, so in closed session, when we're talking about recordings of closed sessions, it's going to depend a lot on the type of closed session. So yeah, you're going to keep minutes. There are certain closed sessions that we are going to record for purposes of, for instance, the example that would come to mind is we're doing an expulsion hearing with a student. We potentially have an obligation by state statute to record that. But in general, our closed sessions are not recorded. They would not, you would potentially have minutes showing what happened in there, but you wouldn't have a recording of that closed session. And I will have stuff on this when we get to this topic and talk about closed sessions in a minute. Yeah, did you have a question?
No, I was just gonna
Oh,
basically say what we do.
oh yeah. Well,
Which
yeah,
is-
if you want to share kind of what your process is, that might be helpful too.
We take notes of minutes, if there's any motions or votes to record,
Yep.
and then they're filed.
Yeah, and the important thing too about the closed, I'll talk about this in a minute, but the important thing too about those minutes and the discussion from that closed session is that might maintain that protected status because it was in a closed session, even after the vote is taken, if the action is taken, if the same grounds for the closed session are still applicable. A lot of times they aren't, but so it's really not it's always this, it's always that. But that's something to know as well, is just because you take those minutes, it doesn't mean that they're automatically public and that anybody can come in and see the decision, the vote, that type of thing. It's gonna depend on the circumstance.
The school board is invited to a joint session with the village board and the town board.
Yeah.
Are we required to put out our own agenda? Or
Oh.
are we covered by the agenda that the town and village are putting out jointly?
And is it a quorum? The quorum of the board
I guess.
doing it?
Could be, yeah, probably.
Yeah, if it's a quorum of the board, I don't think you have to put out your own agenda, but I'd put out your own notice. And make sure that your notice is there, saying that and the way that I usually handle this is, the board is going to attend this meeting with these other groups. We aren't taking action at that meeting, but we are going to receive information. We want members of the public to know we're gonna be there. Because you know, with that kind of joint task force meeting, you're not acting. But you are probably receiving information, so it'd be a meeting, I would just go ahead and notice it, would be the safest.
Yeah.
How about where you post that meeting notice to the public? Always
Yep.
has to be in the same place, it's kind of obvious, but.
Yeah, and I've got that exactly in your materials, so I'll go through that in just a minute, like how it has to be posted, but yeah, it's like, we have the same message board where we normally post things, we have to post it in certain locations. Generally, the nice thing to know is normally that's not the board's responsibility, you have staff that can help you with that, but yeah, it's good for you guys to know that too. So one of the biggest things too with the open meeting law that comes up all the time, and this is the question I get most often on open meeting laws, it's serial meetings and walking quorums. And what do I mean when I say that? Well, depending on the facts, serial communications between board members may constitute a meeting under the open meeting law. And what that would mean is if you engage in these actions and you don't publicly notice it, you have violated the open meeting law by holding a meeting. Because again, remember, when we're talking about a meeting, it's governmental business, discussion, decision, information gathering, and it's a sufficient number of people. So again, government business and a quorum. So how does this happen? Well, it can happen in a number of situations where, for instance, you have groups of less than a quorum who each are in different rooms. Say you're doing like a listening session of the board, and I think this was the case there, where they had little pods of board members who were in each room listening to constituents. And then they got together after that listening session and shared what those constituents had said. But they hadn't posted that as a meeting. That was a meeting because you took information and then a quorum of the board discussed it and shared that information. The information gathering there was a meeting. That's a violation of the open meeting law. And so we do have to be really careful in general. For the most part, you guys are gonna do your work here. You're gonna have your meetings here, in an open meeting, in those sessions. The times when this comes up most commonly, today, in this day and age, is emails and texts. Emails and texts are one of the biggest kind of concerns for inadvertent violations, where we might not even think of open meeting law applies here, but our emails, our texts, our calls potentially do. And this is essentially, it depends on the number of people that are on that email. It depends on the number of people or what is shared. So the biggest example that I would have about this is you guys get an email, say, from a community member. I know for a fact community members do this, where they send something to all 7 of you. And they say, I want you to act on this. This is on your next agenda. This is how I want you to respond. Well, we really, in general, I know that members of the public don't like to hear this, but you as a board should not respond to that. You accept information, and then the time when you respond is here, at this meeting. If you respond to that, and you accidentally hit reply all, and it's got all the board members on it, and you say, you know what, thank you so much for bringing that forward. I agree with you. I think X, Y, and Z, and that's why I'm gonna vote X, Y, and Z at the next meeting. That's a violation of the open meeting law. And you've just violated the open meeting law by hitting reply all instead of reply. And so in general, I do think, and this is getting more into not necessarily the legal realm, but more of the advice realm. In general, I think that having a policy or practice of your board not responding to those, or saying we're only going to have one member who's going to respond to these emails that come to everybody, or send it to our administration to respond, is the safest practice to make sure that there aren't those kind of inadvertent violations of the open meeting law. Other ways that this can also come up that you might not even think about. So you've gone through the training, you know about the open meeting law, you're really comfortable with it. And you say, okay, I know that I can't send this to everybody, but what I'm gonna do is I'm gonna kind of go down the line and share my information with everybody to just kind of get a sense of where they're leaning for the board meeting. Well, once you get to that 3rd other member, remember you count as 4, that's now a quorum of you that have been discussing an item that's going to come before the board. And so it could be, especially if you say things like, this is how I vote, I think you should vote this way too. That is a violation of the open meeting law. So it can happen inadvertently by email so easily that I really think successful boards generally, they don't send emails. They accept information, and then all of your work is here. You do all your talking, you do all your negotiating, you're trying to convince your board members of this or that. It all happens here, because that avoids a lot of those issues with the open meeting law, where we have a quorum having those discussions. Because again, remember, when we go back to the definition, it talked just simply information gathering about something that you've got coming up at a meeting. Gathering that information, receiving that information could be seen as a violation. Now, how does this happen? You guys, practically, you have to get information. You have to know what's coming up at your board meetings. You have to see copies of agenda. You have to, get updates. The best way to do this is that you have your administration provide you with a one-way update, where your administration is saying, these are the things that are coming up. Don't reply to this, but if you have individual questions, you can ask me, because you going to talk to the administration versus each other is fine, because they are not a member of this body. They can answer those questions for you, but going to each other, you start to worry a little bit, and then you accidentally hit forward instead of reply, and now you've sent the email where a bunch of people were talking about it, now you've hit the 4th. So you just have to be really cautious about emails and text messages as well. And the other thing that is really important to mention is that the law presumes, there is what's called a rebuttable presumption of a meeting. So the law presumes that if 1/2 of the members of the body are convened, or if 1/2 of the members of the body are a part of it, that they are convened for the purpose of exercising governmental responsibilities, and thus a meeting has occurred. So what that means is when we have to defend these claims, essentially what we have to do is we have to overcome that presumption. We have to prove, not prove that we didn't, or that they have to prove that we violated it. We have to prove that we didn't violate it, which is a harder standard. And just be aware of that as well. So it's really, you have to be very cautious. I do also like to say, chance social gatherings are excluded. This is where I like to talk about my grandpa, who was a school board chair, who we had one restaurant in town growing up. And I absolutely remember every time we got there, he would look to see if the other board members were there. And there was absolutely, I'm not kidding you, there was a time when he said, I can't eat here tonight because there are 2 other school board members here. And so just know that is not a meeting. Chance social gatherings, those types of things are absolutely allowed. You just can't use it as, for instance, oh, by chance, we all just happened to be at the Village of Somerset meeting tonight. That type of thing, it's pretty clear it's not by chance, but you guys are all at the same restaurant, not planning it ahead of time. That should be fine. So when we talk about, before I move on, questions about emails, questions about texts, questions about open meeting law and how it works with the electronic stuff. Okay. So now to the next thing, when we are having a meeting, we have to give public notice of that meeting. And so this is to your question essentially about what has to be on there. And so the notice, again, go back to what's the whole purpose of this whole thing. Government in the sunshine. We want people to know exactly what we're doing, exactly what we're talking about, so that they know, am I going to spend the time to come in and sit and watch? And so on the notice, we have to give them the time, the place, the date, and the subject matter. What are we going to be talking about? You guys do it with an agenda. Your agenda talks about what are the things you're going to be talking about at that meeting. And we have to be relatively specific. We have a lot of case law over the years that kind of talk about, well, you can't be really vague with your language. You have to have it be enough so that people can understand what you're going to be talking about. So it's important to remember that as well, that it can't just be, we're talking about school business, as this action item. You aren't giving enough details there. So you're saying, we're taking employment action, we're considering approving a contract. You have to give people some idea of what you're going to be talking about. Public comment periods, again, I know we had one tonight, but public comment periods are not required, but pretty much everybody does them. And you have in your board policies that you are going to have them. It's important to remember here that when you have public comment, again, members of the public don't always like hearing this, but the things that people bring up from the public, if it's not on your agenda that night, you can't act on it. You can't do anything with that information. Why? Because it's not on your agenda. You haven't posted 24 hours in advance that you're going to talk about that. So generally when you receive public comments, the response to public comments is, thank you so much for the information. We'll pass your comments on to administration and potentially bring it back at a future board meeting. It's not a back and forth dialogue where you're saying, well, you brought this up, so now it's open season for me to talk about that issue that came there. Because again, we didn't give notice that we were going to talk about that action there. So just be careful with public comments. Now, of course, it's different if they're talking about something that's on the agenda that night, because then you can still act on that on the agenda that evening. And I know I just mentioned it, I keep doing this where I say the thing from the next sentence and kind of step on it, but 24 hours. We have a 24-hour requirement. When we put out this public notice, we have to give at least 24 hours in advance notice of what's going to be on the agenda. And then we're basically prevented. Now, that is to say, there are certain cases where 24 hours of notice was impossible or impractical, and then we try to give as much notice as possible. Typically, we reserve that for emergencies or something new that came up that we have to act on right away. In general, we follow the 24-hour rule, but just know that there are some exceptions to that. The posting, now directly to your question, and it's in the materials too, you guys can just, I'm not going to go over everything that's in these materials, but they're kind of a good reference point that you can just go back to and use later on and look at in more detail. But it does say, I've got the information on posting a notice in at least 3 public places that are likely to give people notice of what's on the agenda. I think you guys do library, and I don't remember where else do you guys do that?
Yeah, we do library, RCU Bank, we post it here
Yeah.
at every school building.
So, and I think the other thing too is, frankly, we also post it on our website. And the internet is where most people are gonna get the information about it anyway, but we still have to go through the process of putting up some paper notices. And also, in the newspaper is an option as well, but generally we're doing it too quick for that, for having to get that there. Yeah?
So what about adding things to the agenda, we have the approval of the agenda, what about adding new topics at that time? What is?
Yeah, so this is a spot where adding new topics to the agenda, there's gonna be a difference here. Because one body of law is the open meeting law, which we have to follow, and another is Robert's Rules. Robert's Rules says that you can add an item to an agenda at any time during a meeting, including during the meeting itself, as long as 3/4 of you vote on it. However, we aren't bound by that. We're bound by the open meeting law, which is more specific and says you have to give that 24 hours notice. So if you're going to add an agenda item, you are absolutely risking the open meeting law violation for not giving proper notice, unless it's like one of those emergency situations. We just had there was a construction emergency out here, one of the buildings was on fire, what are we gonna do about it? I always use the example of tornado. A tornado knocks something out, we have to be able to talk about that here tonight. Something like that is less risky, but it's still, you're kind of skating the line there by adding something at the meeting that wasn't the 24 hours in advance notice.
All right, I got a question for you.
Yeah.
Let's say we have a listening session, and we always ask during the meeting, what was discussed in the listening session? So at that time, we start a discussion. Is that okay?
So this would be where you're providing information to the rest of the board about things that you learned, but not to take action, not to have a discussion. This would be like committee reports kind of thing?
No. Let's say a member of the public comes in during a listening session, and they bring up a concern.
Okay. And are your, how do you handle your listening sessions? Are those like, do you have those as public meetings? Is it a quorum or?
No, it's not a quorum.
Okay.
So it's before the meeting.
Okay.
So
If
up to
you-
3.
If you don't have a quorum, that's more likely a committee. The question would be, I guess the safest course of action would be to publicly notice those. We have a listening session, it's less than a quorum, no action will be taken because it's less than a quorum. But because it's less than a quorum, you have more ability to have a back and forth as a part of that listening session. The other thing that you have going for you is you don't have a quorum, you can't take action on it. You know, in that case, that's very different to me than when you're at a meeting like this, adding something to the agenda versus having a back and forth with somebody who comes into a listening session, which I think kind of the point of it is to potentially have that back and forth and give people some response. So that should be totally fine.
Right, but we're reporting during our meeting about what happened in the listening session.
Yeah, so then that would be more like committee reports, where you're coming in, you know, and so think about someone's on the village committee, the village construction committee. The whole point is you put that on your agenda and you're saying reports from listening session, reports from committees. So if you do that and you're having reports from those listening sessions, you can absolutely do that. That you can say, here's my report, this is what I heard at the listening session. Now, can you then take action on it at that same meeting? Probably not.
Can you discuss anything?
Sharing the information and discussing what was learned is fair game because you have said, I'm sharing, you put it on your agenda, that these are your reports from what, you know, you guys are on so many committees. These are your reports from committees. So you can say, you know, someone's coming in with the village construction committee and they say, you know, city's looking at this for a road. It's fair game for everybody else to say, well, I don't really like that. What should we do about it? At our next meeting, maybe we'll take a formal vote on it.
Sure.
But you can have that discussion, can't take action on it.
So specifically what I'm saying is a parent comes in and they bring up the issue of bullying, for example. And then they bring it up and we're asked what happened during that listening session. We bring that up.
I would say that specific example, I would not touch that with a 10-foot pole. You have so many potential privacy interests coming into play at the same time. The name of the parent, the name of the student, people in the community will know who you're talking about if you're talking about the student. I would never raise at a public meeting private stuff about a student or about a parent by name, specifics, talk about
Sure.
that because that is really dangerous.
Obviously, when talk about their name, you just talk about the issue itself.
Well, yes, the problem is a lot of times, remember, it's a small community. You start talking about the issue, you know, this thing happened at the softball game on Friday. People know exactly what you're talking about. So we do have to be careful because there are state and federal privacy laws that come into play too. It wasn't really what I was planning on talking about tonight. But saying, this is something that maybe we should put on a future agenda, a discussion of, in general, what are our policies on bullying? How do we respond to bullying? Without talking about the specific individual, that's 100% fair game. You could absolutely do that.
Right. But even a discussion without specifics, you could do during a meeting.
Only if it's, like you said, if it is coming back from and making a report on something that's on your agenda. Reports from committees. You could potentially have that. I would stay away from it as much as you can because of the privacy interests that are involved. I would be really cautious about that. But obviously, you know, I think that the thing that I often say is, I just give you guys advice and then I defend you, you know? So like, I'm giving you the advice, I wouldn't do it, but you know, there would potentially be arguments the other way. Potentially be arguments both ways.
Thank you.
Yeah, and is one of the arguments, like, the duty of the board to represent the concerns of the public, and obviously if there's a theme, it's not an isolated thing, there's something, and there's some value to just letting the community know where we stand on it, and if there's a level at which that, you know, can be discussed that is productive, you know, all the way around. Any guidance there?
Yeah, so, and this, again, we're stomping on the stuff I'm gonna talk about later, or maybe I won't even talk about it because we're gonna talk about it now, but it's all about roles and responsibilities. So, specifically, let's talk about student bullying. What's the role and responsibility of the board? You set the policy. You say, this is allowed, this is not allowed, we are speaking through our policy, we don't allow X, Y, and Z. Then you get to a specific student complaint, what's the role of the board? None. You don't have any say, you don't have any role in that specific student's issue. For a whole host of reasons, but the first being that that's more of an executive. You're more of a legislative. So you don't have involvement in that. Now, if you want to say, and this is exactly to that point, hey, we've had these listening sessions, and so we've gotten a lot of questions about, you know, bullying and what are our responses and what do we do. Let's put that on the next agenda for a discussion. And you might say, administration, bring us a discussion and update us on what the policies are and what you guys do. Don't talk about any specific students, but what are your general practices and policies? Fair game, absolutely right. And that's 100% within your ability to do. And you might say, you know, in light of that, what about changing this word in this policy? Or what about adding something to this policy or taking something out of this policy because it doesn't make sense in practice? That's where the board, and that's where you guys really have that discussion and you make those calls because you guys ultimately get to decide that.
Thanks.
What was I even talking about? Let's see. Yes. We got votes and records. Motions and roll call votes of each meeting must be recorded, preserved, and open for public inspection to the extent provided in the law. This means no secret ballots. You don't get to take secret votes. All your votes have to be published. Again, we talked a little bit about it earlier. Unless there's a potential that you know, one of the closed session provisions still applies. Otherwise, everybody else gets to see who voted for what. You can't vote by proxy. You can't send somebody else to take your vote in. You have to be there. Voting in closed session is something that is absolutely allowed. It's not specifically talked about in the open meeting law, but we have case after case after case from 100 years that talk about there are certain circumstances when the whole purpose of your vote in that closed session is related to the purpose for the closed session. So you are absolutely allowed to vote in closed session. You would keep a record of that, and then again, when does that become public? Maybe immediately, maybe not for a few weeks or months, maybe never, depending on what it was. It's going to depend so much on the specifics about what it was. You are required for doing minutes of your board meetings, you're already doing that. And the substance of the minutes, in general, your minutes really only, you see a lot of minutes that are 15 pages long, because they said this person said this, then this person said this. In general, your minutes should be pretty short. They should really be about what was the action that was decided and keeping a record of the vote. What topics did we talk about? What was decided? What was the vote? That's really all you need in your minutes. You don't have to get down to a kind of word for word what happened in that meeting. The other thing to know is you're also recording the meetings. Yeah, go ahead.
There's one exception for a secret ballot.
What's the exception for a secret ballot? Oh, I love learning something new.
Well, I'm sure you know this. It's when we vote on officers.
We vote on officers in a secret ballot?
Isn't that secret ballot?
I don't think it
No.
should be. Should be.
Okay,
That's not.
sorry, I thought it
Oh.
was.
I read that too.
So
And we
how do
have
we
in the
record
past.
that?
That might be something you have to follow up on.
For instance,
Might
we
need to
get-
read through your
we have these little
policies.
ballots Where we circle names, and we're not required to put our name on it, so how does that work?
It's a good question. I'm not sure. I would have to read your policy to see exactly what it says. I don't know that I looked in that. If it, in your officer policy, it says that?
I'll check.
Okay. And that's something I can answer afterwards, too. I can look at it and see.
You can write your names on it and record them in the minutes if that's
I think that's a good idea.
what we want, what you want.
For now.
So, closed meetings. To go into a closed meeting, a roll call vote is required. Everybody has to vote. You have a motion, you have a second, and then you vote to go into closed session. There has to be an announcement by the chair or the presiding officer announcing to those present the nature of the business that you're going to be talking about in closed session. And then there are a couple of reasons that these might have gotten kind of small. But the reasons why you can go into closed session are all outlined in your materials. The ones that you're going to be talking about the most often are three: the considering the employment, promotion, compensation, or performance evaluation of a data of an employee of the school district. When you're talking about a specific employee, hiring, that type of thing. But then you also have a number of other times when you can do it as well. That you can look at in your materials, because generally the process is the same for all of them. That you announce it, you put it on your agenda, you say on your agenda specifically, it's this provision, we're going in under this provision to talk about it, and then you go into the closed session. As a rule, no duly elected member of a governmental body may be excluded from any meeting, and this would include a closed session. So we can't exclude one of our members from a closed session. However, this, kind of the flip side of that is you also get to decide who should be in your board meetings and who should be in your closed sessions, and it should generally only be you. Your administrators. If I'm here, legal counsel as well. A lot of times you get the parents who say, well, I brought this issue forward, I want to be a part of that closed session, or you get an employee that says, I want to be a part of that closed session to hear what you say about me. There's one type of closed session where that might have some traction for an employee, where it's going to be a hearing, but we rarely use that exception anyway. Otherwise, we 100% get to decide who's in our meetings. And we do not have to allow anyone else to come into those meetings. The employees don't have a right to do that, the parents don't have a right to do that.
So when you say we, we're talking about the board voting on that, right? Or we, as a board, we decide who comes to the closed session?
Yes.
Okay, so if there's 20 employees in here and as board members, we don't even realize that they're gonna be here and they're in closed session, that could be a problem.
That would be a big problem.
Yeah, that's
Yeah.
happened.
Yeah. No, that they would come into the closed session, no.
Yeah,
No,
okay.
we generally would not allow. Now, that's something that the board could do. I would not advise to do that
Alright.
in a closed session.
Noted, thank you.
The times that that's different, again, hearings. So if we're having an expulsion hearing, the student, their parents, they get to be there for at least the hearing part, but then we close off when you guys are gonna deliberate
Sure.
and everybody leaves the room. Other than that, that's pretty much it for closed sessions. You do have a duty of confidentiality, so board members cannot record what happens in a closed session other than the minutes. You can't, pull out a phone and start recording. You can't take your own minutes about, what was said, who said and did what. And then you can't talk about it. outside of the closed session. You can't share information that you got in the closed session outside. Other than, again, if the vote becomes public, the vote becomes public, but what was discussed in closed session is absolutely confidential, and you have to keep it confidential. And there are many ways, again, I know I mentioned this before, but board members owe a fiduciary duty to the board, and this is one of the ways that board members can violate that statutory fiduciary duty, is by sharing something that they're not supposed to share, going out and explaining something that happened in closed session. And you know, I have the information in your materials as well. That's a class 1 felony in Wisconsin. And I've got examples in here of things that are, you know, are potentially violating the law as well for board members. I hope we never have to talk about it. I hope we never get anywhere close to that. But just know that your actions as a board member can be a crime, especially if you're violating your obligation and your fiduciary duties. Examples I've got in the system: if you provide private or confidential information, say to the plaintiff in a lawsuit against a district, disclosing confidential information from board discussions in a closed session to a teacher who's like a friend, disclosing confidential information to the newspaper or to a reporter, indicating to a contractor of the district that you're acting in your capacity as a board member and then engaging their services, trying to contract with them, obtaining services on behalf of the board without authority to do so, trying to hire somebody when it's not coming from the board. And I've got a really interesting hypothetical in here. I realize that I'm already starting to get to near the end of my time, but I really think this is helpful. In your materials, I've got this question: does an individual board member act in excess of his or her lawful authority by making statements at a board meeting that they know to be untrue, or making statements in reckless disregard for the truth? Is that potentially a violation of your fiduciary duty under state law? And I would argue that it absolutely could be, because one of the definitions of that kind of malfeasance and the violation from the statute is about the intent to obtain a dishonest advantage. And so that kind of intent to obtain a dishonest advantage could absolutely put an intentional lie that a board member tells during a board meeting in that realm of the kind of felony violations. How likely is that to happen? Not very likely. And how likely is it that anybody's gonna lie? I mean, again, not very likely. But just be aware of that is out there, and that is one of the things, that kind of intentionally trying to get a dishonest advantage. The attorney-client privilege is held by the board as a whole. So again, I know I used a couple of these examples already, but one board member can't choose to waive that on behalf of the whole board. There are absolutely situations I've been in my career where we decided to waive the privilege so the information that I shared became public, but that was a decision by the full board, not by any individual board member. And again, I've got this here again, there's no right to record a closed session, that people don't record the closed sessions in any way.
Can we go back real quick to the attendance at closed sessions?
Yeah.
So the board decides who's there, but just because we decide one way doesn't mean that's always how it is, right?
Right.
We could have an SRO here, and we could have the principals here for a closed session, right? Depending on the topic, we can choose
Yep.
the attendees.
Yeah, you don't set any kind of precedent saying now we have to do this way every time, because frankly, every closed session's different. They're about different topics, they're about different employees, so you're not setting a precedent if you do it one time but not others.
Okay.
But I'm use the example of an expulsion hearing. We might decide that in that expulsion hearing, we need the principal, the assistant principal, the SRO. We might need other students to testify. So you guys get to decide that. You know, generally that's something your administration is going to help with as well in that kind of context. But then in the next time, you know, the next meeting, you don't just get to say, well, the SRO came last time, so he gets to come this time. You might not need him. So yeah, you get to make that call kind of on a case-by-case basis.
Right, thanks.
I've got information on penalties in here, violations of the open meeting law for all these things that we've just talked about. That's worth you guys at least taking a look at. You know, and it might not just an individual penalty or an individual crime, but also it might void the actions of the board. Actions that happen in violation of the open meeting law may be void. The worst case scenario for that would be if, say, we had a construction contract where we approved it at a meeting that we were in violation of the open meeting law. That contractor could be like, well, we're gonna do shoddy work, that contract's not valid. If you try to say breach of contract, we can say, well, you took that action at a meeting that violated the open meeting law, so there is no contract. And so that's the worst case scenario. It's kind of a hypothetical that I've thought about that I don't know that many people out there have ever thought about, but that's my worst case scenario. Where could it get if the action's void? Before I move on from the open meeting law to talk about maybe just one of the other topics I was going to talk about tonight, are there other questions on open meeting law, process for notices, when we have to do anything, closed sessions again, anything else you guys want to talk about or have questions about?
Or did you find that policy?
Yep,
I did
it's
too.
policy 0152, and it states secret ballots may be utilized only for the election of officers. And it's been that way. I've attended school board meetings
Yeah.
for 37 years.
So if you've set that by your policies, there really shouldn't be any kind of a violation there. Because you've set that by your policies. You have said that that's the only time that you're going to use it, and you are announcing the vote as well.
Yeah.
So in general, any other time, no. We don't use open ballots, has to be public, but if you have it in your policies, you should be fine on that.
So, how else can you circumvent open meeting law with policies?
You really can't in general. If you had a policy that specifically violated it, that's the type of thing that you could not do. The language on that specific section is probably not that clear, saying that it has to be in every action that you ever take. I think probably for purposes of this outline, I just put it in more broad terms without talking about specific exemptions. But no, in general, you don't get to by policy decide we're not going to follow this law or we're not going to follow that law. And then one of the things that comes up too is people say, well, what do these policies mean? Do they mean that we have to follow this policy? Well, number one, the board can change a policy. And I often see in lawsuits where someone says, we're suing you because you didn't follow your own policy. And the answer to that is there isn't really a cause of action for us not following our own rules because we can disregard them at any time. So we aren't creating necessarily legal liability on ourselves to ignore our own policies and do something different in a specific circumstance. It's not a good practice. You might want to change the policy. That might be easier, but just know that just because we violated one of our own policies, it doesn't mean that there's a legal cause of action that could be brought forward. It comes up a lot. People say that in a lot of lawsuits, but there isn't a claim for it.
However, we hire a company to help us with our policies, and most, if not all, of our policies cover state statutes. And the Wisconsin state statutes that are involved in every policy are listed at the bottom of the policy.
Yeah, I like that.
So there is the potential of, if we don't follow our policy, we could also be breaking the law.
Yep. Yeah, and you'd want to yes, you would absolutely want to make sure, because you can't violate the law, but if it's a policy that is within your discretion and you decided like how you were going to say this or that, it's not something that we're creating legal liability for unless it violates the law. Yes, thank you. Okay, I want to talk a little bit about responsibilities and authorities. So, management of the school district. Ultimately, you are the policy makers. You are the ones that are in charge of everything that happens at the district from a large scale level. That you get to manage the property and affairs of the district. And that board members have a duty to maintain the confidentiality of information discussed in closed session. No information that's discussed in closed session, again, should be shared with anyone who's not as a part of the closed session. I think that might have been, yep, that was the wrong thing. Sorry, that was just a copy and paste from the last one. But again, all things reasonable to promote the care of education, that's straight from 120.13. That's the obligation of the board, to take to promote the cause of education. I also have in here your policy 144.5. Almost everything I'm going to be talking about comes from that. you should go read that policy instead of having me talk to you about it. Because it's very comprehensive. It talks about rights, responsibilities, what is board member business, what isn't board member business. That's very helpful. And I'm just gonna talk about a couple of just general pieces here. And the best example and the best advice that I can give is you guys are macro management, not micromanagement. You set the roadmap. You say, these are the big goals for the district. And then you turn it over to your administration to get you there. You create the map, they drive. And so that goes for employee issues, that goes for student issues, that goes for anything day to day. Contracts have to come back to you. You guys are the only ones that can really enter into contract unless you delegate that authority to your administration. But generally, you're setting budget and policy. Those are your goals. Those are your obligations as a board. And then everything else goes to administration. In general, the example that I also use all the time is, especially when we talk about employee stuff. Obviously, there are a lot of employees at the district, but you as a board only supervise one employee, the superintendent. That is the only employee that you supervise. Everybody else is really outside of your course and scope, outside of the actions that you guys can take, because you just have the one employee that you supervise.
Is that written into a statute, like 120 or 118? Or is there one that we just are involved with the superintendent or one employee?
No, that would be your policies, and that would be in general.
The policy's not the law.
But your policies and also kind of the law, I mean, it's not a specific, it talks about what your obligations are under 113, which was, oh shoot, I've got the wrong one in there anyway. But generally, you're managing the property and affairs of the school district. And one of the things that we're going to talk about here in a second is all the potential problems that could come up if we don't follow that chain of authority. But you guys hire and evaluate one employee. You don't do employee evaluations for principals, for teachers, for bus drivers. That's really outside of your roles that you've set for yourself in policy and that also state statute talks about.
Yeah, I was just curious where in state statute it says we don't have that broad authority.
Yeah, so I'm paraphrasing. That's the way that so again with the last one, I'm kind of using general language here. And a lot of this too, it's in your own policies, it's taken from state statute, it's taken from court cases. I've tried to put in the materials all the citations where there's a specific citation because I like that so that you can go back and look at it. But also this comes from experience. This comes from seeing boards get in issues. And then I think to myself, that's going to be a good thing to put in the next training document, is we've got a new issue that's come up here. So for certain it is in your policies. 144.5 talks all about that. And I think that it's also kind of taken from some of those other sources as well. The board also, and I think this is something that kind of trips people up from time to time, that the board acts as a body and that individual board members don't have any real authority to act on their own. They don't have any authority from state statute, from policy, or from any kind of court law that says board members get to do X, Y, and Z. They have the right to take this action or that action. Your only role, your only responsibility, where you get authority is from this body as a whole. That's where your authority comes from, because the board is allowed to act. In each one of those state statutes, it talks about the board has this ability. The board may take this action, not individual employees. And this trips people up a lot. Because individual members have a real limited role. Your role really is to prepare and be ready for these meetings, because these meetings are where your actions are going to take place. These are where your decisions are going to happen. And acting on your own, unless you've been delegated that authority, there are absolutely situations where the board might say, we're delegating the authority to take X, Y, or Z action to you. We're saying you go do it. The best example of that is you by policy have authorized your board chair to do a lot of things. Your board chair is going to take certain actions because you've given that authority to them. But otherwise, individual board members really don't have that kind of individual authority. And one of the things that this causes the most problems anywhere. You guys are not, you're not immune to this. This is what it is everywhere, every single school board. Biggest problem is chain of command and realizing kind of, again, I have to draw that line between rights and responsibilities of a board member. I've seen the emails you get. I know what they're like. Boards get emails saying, hey, this is happening in my kid's class. What are you going to do about it? Hey, I'm mad about this thing that's happening over here. What are you guys going to do about it? And ultimately, the best advice here is that when you're talking about these kinds of things, when you get those concerns and citizen complaints, you document them, you make sure that you received it, you read it, you have an email, that email is going to be saved. So you've got it, you've documented it, and then you direct the citizen to the superintendent or principal, as the case may be. You send them to the right person who's in the position that can actually help them. Provide appropriate contact information, inform them that you will be telling the superintendent or principal, and then also follow up and tell your principal or superintendent that you're sending this person to them and what the allegations were. And then explain as well, if you want to, that you have written complaint forms, that those are available on the website, they can review them, those will give them information. But that's your response to citizen complaints. There's no other action after that, because it's not a board issue yet. If it becomes a board issue, you'll know about it, because it will come back to you at that point. And so it is this chain of command that is going to save you guys in these kinds of situations. Responding to anonymous complaints are exactly the same. We don't ignore complaints simply because they're anonymous or someone has put a fake email address on it. We take all complaints seriously, forward those on in the exact same way. And then citizen concerns as well, it might not just be in email. You might be pumping gas and someone comes up to you and says, hey, I got this thing going on at the elementary school. My teachers are being real mean to my kid. In person, your response is exactly the same. Now, you're human beings. Absolutely, you can say things like, I'm so sorry to hear that. But your answer is principal. Talk to the principal. Here's the contact information. I will follow up and let the principal know that you're calling them. That's the proper person to handle to answer your questions. And reasons why this is so important. Number one, you guys aren't necessarily trained on how to conduct investigations. You may create legal liability to the district based on how you ask questions or the kinds of information that you might solicit. I know that sounds like, well, of course we're not going to ask the question that's clearly discriminatory, but there are so many pitfalls that you can run into. It's why people get trained to do these kinds of investigations and to ask appropriate questions. Board members who investigate on their own might also impair the integrity of an existing investigation or a future investigation. Just someone coming up to you at the gas station and saying, hey, this is going on in the school, you don't have any idea what they've already done. You don't have any idea, for instance, that principal's already doing an investigation and has interviewed 3 or 4 of the people that were involved. And so if you jump into it and start asking a bunch of questions, you might harm that investigation that's already going on. Individual board member, just getting what you're getting from that member on this, that person, the parent on the street. You might not know the full story. You might not know what's been done in the past or what's happening right now with respect to the issue. Best example I can use of that is my kid's being bullied and nothing's happening about it at school. And you say, well, gosh, let's do something about this. I'm going to start looking into this. Well, you don't know that actually that is the bully that's been disciplined 3 or 4 times already this year. And now he's trying to essentially claim that, oh, it's actually me that's being bullied. So you don't know that, for instance, there have already been investigations, there have already been discipline for all these scenarios in those kinds of cases. You also have to ensure that you have a clear, consistent, and lawful message delivered to the complainant, the witness, or alleged offender, because so many laws specifically require us to take specific actions that, for instance, it might not trigger your mind to think this person at the gas station just said this thing, that might be Title IX. And then we might have like 15 other obligations that we have to do if that's a Title IX investigation. You also often, I've seen this a lot, that board members who go and start asking questions put employees in untenable situations and create stress for employees. I will share with you 100%. I've had board members who walked right into schools and started like going into class and asking people questions. And people are like, well, is this kind of my boss? Not really my boss? Like, what are they doing here? Why are they asking me questions? It puts employees in a situation can lead to harassment or discrimination complaints for the board members. This one's really important, number F here, or letter F, that if you investigate on your own, you might be considered to be biased if a student or personnel issue later comes up. So let's use the student bullying investigation. This one's actually so bad that it's coming to you for an expulsion. Well, now you have information that you either gathered yourself or that you got from the parents that wasn't presented at the expulsion hearing. And then if you rely on that information, or if they even appeal saying this person was biased because they knew about it ahead of time, we lose. That's a ground for overturning an expulsion decision. So then you went through the whole process of expelling a kid. DPI says no, you have to put him back because you had a conflict of interest. You knew too much about it. Parents had shared that information with you. And so it also is, again, it's just not the proper role of a board member, can potentially impact and undermine the superintendent's authority with their staff. It's just not how good boards operate. What not to do. When you get these things, what do you not do? Well, don't pick sides. Certainly don't promise a particular outcome or cause of action to that parent. Don't promise confidentiality, because a lot of times we can't promise that. It's going to be public. Don't do the investigation yourself. Don't act outside the process or act as the decision maker, because again, it might come back to you, the body, as the decision maker. Don't offer to personally address the concern. I call this the hero, where, oh, I'm gonna take care of it. I'm gonna go down and knock some heads together in the elementary school so that we get this done. Think I'm joking, I'm absolutely not. And don't go directly to employees below the superintendent. Not your role, outside your authority. Causes all kinds of issues if you do that. So I'm kind of at 6 o'clock. I think that it is worth it for me to spend at least 5 or 6 more minutes going through these hypotheticals, because I think that they are so important and they are based on real life examples. And then I'm gonna skip and I'll let you guys kind of on your own look at the the pieces about conflicts of interest, because again, that's important, but you guys can look at that. Generally, that's really mostly about having monetary conflicts of interest. So hypothetical situation number 1. You're on the school board. 2 high school students, Ed and John, get into a fight at school. John is your neighbor's son and is a model student. Fight begins when Ed, an EBD student, sucker punches John in the face. John throws 3 punches and knocks Ed unconscious. John is subsequently suspended from school and is arrested by the police. Meanwhile, Ed is taken to the hospital in an ambulance. The following day, your neighbor approaches you, begins telling you about the fight between John and Ed. Your neighbor then asks whether you think it was appropriate for the principal to suspend John, and whether the district will be seeking to expel either John or Ed. How should you respond in this situation? What should you say back to this parent? What do we think? Have I drilled it into you enough that everybody knows the response? That's why everyone's laughing at me. In general, it's, talk to the principal, send that back to the school. Not my role, not my responsibility as a board member. I'm so sorry you're going through that, but you really got to go through the principal. Talk to the principal about that. Because here, you absolutely have situations involved in this that might be expulsion level, that might come back to you. You want to make sure that you keep yourself separate from it. So same facts, except that your neighbor shares that he's very frustrated because he had repeatedly told the principal that Ed was bullying John, but the principal failed to take any action. Your neighbor also asks whether you knew that Ed had been in 2 other fights at school and whether you knew that he received special education services at school for a serious emotional behavioral disorder. You were aware of that information. How should you respond to your neighbor? You share that information with him? You say, well, this is an EBD student, of course this is what's gonna happen. Or you're gonna start talking about it? No, especially where you have background information on it. That is very private. That's some of the most protected information about a student. And if you do have that information and you share it, you potentially violated state and federal law by sharing that information. So we have to be very cautious in those kinds of situations, especially where you have details about the scenario. So same facts, except John is your son, and you would like to access Ed's education records in order to see whether they contain any information that would be helpful in defending John against the criminal charges. Your kid's been criminally charged. You just want information to help his defense. If the administration refuses your request for Ed's records, would it be appropriate to ask the board to vote to give you Ed's records? No. No, absolutely not. Again, as I said, these are all from real examples. So no, of course not. In that situation, there would be no grounds for the board to say you have a legitimate educational need to know that private information from that other student's file. Okay, so hypothetical number 4, you're a member of the board. A close family friend who's a resident of the district comes to you and tells you that she's upset because the district is refusing to provide her child Mary with simple accommodations that she needs in order to be successful. Your friend tells you that Mary's IEP team is being unreasonable and asks you to either intervene on her behalf by calling the IEP manager or to attend the next meeting with her. Your friend describes the accommodations that she's seeking for Mary and you think the accommodations are pretty reasonable. How should you respond here? Do you go sit in at the meeting? Represent her at this IEP meeting? Call the IEP manager and talk about it? No. No, in these cases, you gotta go through the processes, especially where we're talking about IEP meetings. If a parent disagrees with an IEP decision, there are numerous ways that they can challenge it. They can make us go to mediation, they can file a due process complaint. There are all kinds of ways that we can go through this, and in all likelihood, based on lots of experience, she might not be telling you the whole story. There might be a very good reason why we're not offering a specific accommodation, and we've had to give her what's called a prior written notice on why we're not giving her that particular accommodation. So yeah, you would absolutely not want to step your toe into this. So you're a member of the board. The board votes to require students to observe a moment of silence at the start of each day. You and one other board member vote against the motion because you believe it may make some students feel uncomfortable if they see other students bowing their heads in prayer during the moment of silence. The remaining members of the board vote in favor of the motion. After the meeting's over, the other board member who voted against the motion asks you to join him in trying to get hundreds of residents to sign a petition asking the board to reconsider the issue. How should you respond in this scenario?
No.
Yep, generally the answer is no. Other than times through Robert's rules when you can make a motion for reconsideration, once the board has spoken, even if you're on the losing side, the action is over. The decision has been made, and you in your board member role have to accept that and move forward, unless again, there are those specific situations that might allow for reconsideration. Now you in your private role, as an individual, not as a board member, you could theoretically have some First Amendment right to do this, but this would be a huge issue that is then going to cause a wedge, and then you're not going to function together. You guys aren't going to work together very well if you're going to start undercutting the actions of the full board just because you were the one who lost. So the answer should be absolutely no. I would also worry here, did anyone else catch the other issue? That's 2 of you. It's not 4 yet, but that's 2 of you that are talking about something that might come back before the board, not at a public meeting. I'd be a little cautious there. That you want to make sure that they haven't talked to anybody else, or that they don't say, I also talked to these other 2 members, and now 4 of us want to overturn this. So be really cautious there too, because that's how easy it can be to have an open meeting law violation.
Before you move on.
Yes?
I don't know if it's in the state law or if it's in Robert's Rules of Order, but I believe that when a vote is reconsidered, only a person who was on the side of the majority can ask for the vote to be reconsidered. Is that correct?
Yes, that's Robert's rules that you guys have adopted.
Okay.
Not in state law. State law doesn't get that clear about specific violations, but Robert's rules has specific rules about when something can be reconsidered, how often, who can make the motion for reconsideration, all those things. I will say I don't have Robert's rules memorized. I do know that one. I'll never forget the first question I ever got at a board meeting was a Robert's rules question, and I had to be like, no idea. I don't know. We don't study that in law school. So that's one I actually know. So you're a member of a board. At an upcoming meeting, the board is scheduled to vote on whether or not it will renew a teacher's annual contract. The teacher is a long-term member of the community. Shortly before the meeting where the vote will be taken, another board member approaches you confidentially to share her concern that the administration is proposing to not renew the teacher based on a personality conflict rather than on performance. Board member also tells you that she promised the teacher that she would vote against any motion to not renew her contract. The board member also tells you that she has convinced 2 other board members to vote against the motion as well. She then asks whether you are willing to vote on the motion so it will pass. How should you respond?
It's a quorum.
You run screaming in the other direction. Yes, absolutely. You have all these worries here that number one, you're acting so far outside the course and scope of your duties here. You have a board member that's going through and saying, I'm doing my own investigation into why this is coming forward. You have a quorum here. Now they've shared information with the quorum. That's an open meeting law violation. Yeah, so this is kind of a worst case scenario. This is like a you run screaming in the other direction type scenario. Same as in 6, except the administration transferred the teacher rather than proposing her non-renewal. Another board member tells you that the administration acted unfairly in transferring the teacher and asks if you will join in a vote to overturn the administration's decision to transfer the teacher. How should you respond here? The answer to this one is the same. No. It's not within our scope, it's not within our responsibilities. Now, when it comes to you to decide on the renewal or non-renewal, yeah, that is a board responsibility, that's a board role, but kind of day to day, you know, having these kinds of things happen, you know, or transferring a teacher into a different position, that's considered an inherent managerial right. That would be something that your administration handles, not a board issue. And so, you know, that would be something where you'd say, no, of course I wouldn't join in that motion. Now, let's, just to say there might be situations when we might want to look at this. Well, okay, what if that teacher, instead of talking to the board member, makes a discrimination complaint? They file a formal discrimination complaint against the administration saying they transferred me because of my disability. Well then, yeah, it might become a board issue because the complaint is against the administration. That would be a situation where you're probably working with legal counsel to do an investigation into that potential discrimination complaint. And it might become a board issue. But just the general kind of day-to-day transfer stuff, no, not within the board's purview.
And even if that happened, it wouldn't be the board doing the investigation. We would hire someone to do that investigation.
You would really want to do that, and the reason why is kind of one of the reasons that we talked about of you are the decision maker.
Right.
So you don't want to be the ones that did the investigation and potentially have either preconceived notions or have information that the rest of the board doesn't have, because that would be a very easy allegation in that lawsuit, saying, well, actually they were biased against me because they did the investigation. They should not have participated in the vote on my contract. And I think my goal in all of these types of things is to avoid issues. And we don't want to have that issue, so when we can fix it on the front end, let's fix it on the front end. Where we just say, no, let's have an independent investigator do this investigation. Okay, another board member, this is the last one, and then I'm gonna stop talking. Another board member sends you an email complaining about a particular student's misconduct at school. You reply by email and state that you have the same complaints and concerns based on your own child's experiences with the student, based on the fact that the board was contemplating expelling the student the previous year. You also state in your reply email that the student is not really to blame. You explain that the real problem is the parent's lack of intellect and parenting skills. You jokingly conclude your email by saying, I guess the apple does not fall far from the tree. What concerns would you have if this occurred?
Open records.
Absolutely. So if that family made a data request for all emails about their child, do they get this email between two board members? Yeah, absolutely. 100 times. Yes, they get this email. Remember that the emails and text messages that you guys send as board members are generally public. They're almost always public. Anybody off the street can come in and get them. They can say, I want to see all emails that every board member sent in the last 10 days. Okay, yeah, they get it, unless there's something that's private in one of those emails. So for instance, you know, in a situation like this, because it is that child's information in that email, those parents get it. But parents from down the street don't potentially get to come in and see that email because it's about that student. So it's private educational data on that student. But yeah, I can't tell you how many times in responding to a data request, you see teachers use inappropriate nicknames for students. They get, you know, they forget about those things. You're like, well, when the parent sees that, that torpedoes that relationship. So you have to be very cautious about what you're putting in emails. Yeah, also, you're talking about all kinds of other things in here, you know, about what occurred. So yeah, there's just a whole host of things that are going wrong with this one. With that, does anybody have any questions or topics that they wanted to ask me about before we even started and I just gave you an onslaught and avalanche of information? What questions do you have?
Well, can you also mention what's included there, that deleting the email is not going to fix it?
Yep, deleting the email doesn't make it go away. And it is the type of thing that when you delete emails, they're still on the district system. And that's by design. That's to ensure that we aren't inappropriately deleting things that we have to maintain by law. So yeah, just deleting it doesn't fix it.
And I might add,
Yeah.
BCCs don't alleviate,
Yeah, putting somebody as BCC, also, it shows up in the email system. There is a record of who you sent as BCC. So that doesn't necessarily alleviate that problem either, 100%. And because this is technically data on a student, we're obligated to maintain this. So we don't get to just simply delete emails that we think are gonna be bad for us, because we'd be violating other laws by doing it. So yeah, that's not a good one, for sure. Other questions on any of those topics or anything else? Okay, perfect. Thanks, everybody.
thank you.
Thanks for doing this, yeah.
All right. Great information. Again, sent out some additional information Friday. I think that he shared with us Friday, and then everybody should have this email to them as well, the rest of that PowerPoint. The next item on the agenda is the compliance certification request that's been sent to the states. So, and then this is for board member discussion and possible action. Anybody want to start our discussion? Make a motion? Wise.
Well, I think it's too late. So,
So at this point in time, it's not required, because it was pulled, I believe. But what's the harm in actually signing the certificate?
Well, what's your latest information that you're saying?
Let's see, so, there is, I think I sent that out for information only last week, but, Wisconsin Institute for Law and Liberty does have a letter going to the federal government with like a consortium of school boards that missed the deadline, who regret that choice and would like to sign on to that, but that deadline for that was May 1st, so we missed that as well. So,
But it still could be signed, even if it's late, at least we can be on record that,
sure, I don't think it would hurt to sign it at all.
yeah, that's,
I thought judges have already, didn't we get, you sent us a lot of emails, Bruce, that
Yeah.
judges have already stopped this?
Yeah. That's how I understand it. I understand the state of Wisconsin is pushing back against it, and our judges,
Have
They've
to
also
stay out
stopped.
of the order.
yeah.
but that in itself does not prohibit us from signing that certificate.
No, and I guess my perspective is I don't think the government knows what needs to happen yet. I think they're still trying to figure out what needs to occur before we would do anything. I don't know why we take any action until they've kind of figured out in their court system, kind of like we did last summer, that we ended up tabling the Title IX is the same. They're still out, still for discussion. I don't have any reason to keep discussing it or going forward with it. I think
What is the community input? Do you have any info on that?
I had lots of requests to talk about this before the deadline. That's why I was pursuing it, but. So I guess now we just wait and see.
All right, does anybody have any other discussion on this item? Let's move on to the next. All right, next item, Robert's Rules. So this, I just wanted to point out to everybody, just for some of the meetings, or all of our meetings, it's at the top. If you go all the way to the top, Alicia, we just scroll up quick to the top, please, and show. It just says, in our notice to public, if you click on that link for the Robert's Rules, it pulls up this information that you can print off or you can review of just, some of the highlights that we use at meetings. I know last summer when we were doing some of our things, I think I got an email from somebody that, hey, you can't do this per Robert's Rules, just for a topic, a discussion topic. So I went back and looked, and yeah, they were right. A tabled item doesn't have discussion. So just something for reference for everybody. If you're wondering, we've had it, adjournment isn't discussion, just a few topics so you know what items are up for discussion, what actions aren't up for discussion, common things that go on at meetings. Just one of the things I think I wanted to do with this, coming a new board, a new year, if there's anything that we want to do different, that we want to handle based on, that is in here, because we don't follow this perfectly, and if you watched other boards do things differently than we do. But if there's something people want to do or we want to add that's in here that we should, discuss it, amongst ourselves, and so we're all on the same page, so we don't have things that we've had issues with. I just figured it was good to discuss and run through and review it if no one's looked at it before. Just another guide for reference. A big one, just this parliamentary procedure at a glance, just what you can interrupt, what you can't interrupt, what must be seconded, is it debatable? It's on the third page. Things to know coming into these meetings. That I think we talked about Robert's Rules multiple times. How to make an amendment to an item is always one of those, how do we amend that motion? And, or we sit around, okay, now how do we vote on it? So that's all on the last page. So just, again, knowing where it is and what information. So I guess if anyone's looked at it or has thoughts on things they'd like to address, or we just kind of keep going with what we've been doing.
How about, and I don't know if this is pertaining to this or where this falls in with all this, but like having an agenda item for board member comments. I've seen a couple other districts that have that, and they keep it to, I think, what they would like to see. Did we discuss this before?
Yes.
Future agenda items.
And we decided that it is potentially a violation of the open meeting laws. And I believe we got advice from Trevor on that.
You're talking about putting something on the agenda?
The ones around the table.
The ones around the table.
Yeah, not on the agenda, just the end of the meeting, bring up a topic.
Right.
Yeah, and that's why we changed it to the district separation.
Celebrations.
Well, what would be the harm in getting something on the agenda for the next meeting at the end of our session?
But I think what happened was the discussion started to get too deep, and maybe Trevor can speak to it. I mean, if somebody brings it up and there's absolutely no discussion, that's probably not an issue, but if there's any discussion around it, suddenly now it's discussion around something that was not on the agenda, right?
Yeah, I think you always worry a little bit about when you have a topic that you're bringing up to talk about, that you're gonna wanna talk about it. And you're gonna wanna discuss it, and then you have the whole issue of it wasn't noticed. Members of the public weren't told that you were gonna talk about that. But yeah, I think to your point, if you said, I guess, I don't know, if you could do any of these things without any discussion, but I also think we're human beings and that's incredibly hard. And I think so the only other thing I'd say is that in general, these are generally disfavored. Like the AG's office has said in their compliance guide very specifically that these are disfavored because of how they can easily devolve into violating the open meeting law.
Well, transparency issue. I mean, we're talking about sunshine, right, on our meetings? And otherwise, we're bringing things to the agenda behind closed doors. Here, we can actually bring it up and get it on the agenda without discussion. It seems logical that we would add that as a course of action we want to go with moving
As
forward.
long as everybody is very, very careful.
Sure.
Yeah, well, I mean, just to get to maybe the higher level, what's the motive? What I think I'm hearing is, to have more dialogue done the right way to make sure everybody feels heard and that whatever concerns you're feeling or opportunities for areas of improvement, high level things like this, is that what you mean? Not agenda specific topic issues, but more like, thoughts on more general type
We
things?
can have those discussions. We can have, correct? I mean, the discussion has to be about the agenda topic. And that's why we changed it to the email, right? To the board president, and then a second, that got it on the agenda. So we didn't eliminate that. Like, somebody can still put anything on the agenda. It just took away that possibility. And I understand, like, seems logical, but if the legal counsel is saying we shouldn't do it, I mean, I think we have to go that route. I mean,
I don't know, you didn't say that, though. You didn't say we shouldn't do that.
Yeah, I mean, I just advised you guys make the decision. But I think the worry is, especially if you're talking about something like, and it's been a while since I've looked at your policies, on how many you need to put something on an agenda. That's getting awfully close to a vote on something that wasn't noticed on your agenda. So it would be much safer if you were going once around the table to say, this is something I'd like to see us talk about in the future. No more discussion, not I'm seconding that, let's put it on the agenda. It's getting close to like a vote that you didn't publicly notice. And especially then if you're gonna have other people say, well, no, I don't think that should go on an agenda for X, Y, and Z reasons. Now you're off to the races on violating the open meeting law.
So I would add too, the reason we put things on an agenda, and then we usually don't make, the majority of the time, we do not make, take action on that first meeting, and so there is plenty of time. Like, if it does come up, you know, we do pass around, hey, I want this on the agenda, it gets posted on Friday, we discuss it on the Monday, and then usually it's another 2 weeks before we take any action on that item. That's the majority of our items that we try to make happen that way. So that there is plenty of time before we would take action, we can get back and forth.
Well, then going back to sunshine, if the public knows that something's gonna be on the agenda, because we got it on the agenda during the session, they will be well aware that in 2 weeks, that's gonna be there. Otherwise, they may not know until the Friday before the meeting.
I would say too, I mean, there's a lot of things that go on these agendas, or that are already predetermined on, you know, the next agendas that we need to discuss. You know, sometimes we don't have room, or there's already other topics going on it. Well, yep, we'll get it on, just not on the next one. I mean, that's between as our policy says, the president and the superintendent to build an agenda.
so how would you advise on if a board member wanted something to the agenda, what's the most advised process?
I think probably what you have now, which is that you can make a request to the chair and to the superintendent who built your agenda to put something on the agenda. If we don't like what the board chair is doing, the board controls who the board chair is. You know, so not to say Bruce is doing something wrong, but ultimately you still have some recourse there. If, for instance, you say I keep banging my head against the wall, I'm not getting anything on this agenda, well, then you vote for somebody else in the future.
Would you say eliminate the second? I mean, if one board member wants something on, and that's up to the board chair to decide at what time do you put it on?
Yeah, and I think the other thing too is a lot of times you can answer your question and you don't need to do anything just by talking to the superintendent. What's going on here? And you know, a lot of these issues are avoided by like open communications where you're saying, hey, I'm hearing this thing. Should the board consider any action? Should the board do anything? and those types of things. It avoids this. This just frankly doesn't come up that much. It's not that huge an issue, so that's why kind of the idea would be you guys are being as safe as you can possibly be by, you know, not having potential. It's just human nature is that if someone's gonna say, I want this on the agenda, someone else says, I don't want it on the agenda, you're talking about it now.
And to your point, Matt, about a second, is because we were getting items that weren't getting put on the agenda by the president, and, you know, just wasn't going on. So we did start that, hey, email it out to everybody, and then second it to the president, yeah, we want it on. Now, you're not discussing it, it was just, yep, I want this on. You know, someone would put it out, and that's, so we could make sure, yep, it will be on a future agenda.
So right now, the sentence in our policy is, individual board members may include items on the agenda upon the concurrence of at least one other board member. This may occur through email prior to the Friday before the meeting.
I think typically your concurrence would normally be the board chair, because the board chair is a second. So that's clearly set up to say, someone can email the board chair, and if they agree, they can put it on. But then I suppose there's that secondary piece there of an idea of, if the board chair doesn't agree, you go out and get another person.
It says upon the concurrence of at least one other board member.
Which the board chair is
So the
one.
practice that we've been using is
Yeah.
that, well, Bruce, you've been handling that, Ron.
Yeah, it's just, someone will send an email out to the entire board and to say, I would like this added to the next agenda, you know, to discuss, you know, the certification requirement. Is there, you know, someone please second. And just email myself or email president or email Bruce and, you know, whoever sent it, to know it'll be on there. And then usually no one else responds if they don't want it, and then the person who does, or if the second does, then it goes on. And then there's no other discussion. Again, it's like, to your point of saying, there's no discussion, it's just, I want it on the agenda, I second, I want it on the agenda, and then we can discuss it at the meeting.
Yeah.
And then the right time to discuss why it's on the agenda, which I think is a huge helpful point to the community. Why? And what's the goal, you know? But then the other side of that is, the community never gets to hear the why nots.
Well, so for this, so one of the things is, what I've tried to do is, like, if someone does add it to the agenda, and like, you know, the policy that we updated, you know, if Danny brings something in an email that says, hey, I want to add this to the agenda, usually it's, okay, you wanted to bring this, you know, go ahead, explain, and then, you know, if people don't have much that night, or they want to do it, you know, they can come back before we vote on it. I think we've had some back and forth on those about not why we don't want it on the agenda, but why we wouldn't want to
Take a
have that.
particular action.
Or take, yep, that sounds good to me, let's do that, or I think we've had a lot of discussion on those, I think anyway. Maybe we could do something better, that we make sure that we hear from both sides, because, so how it works and how it kind of goes in here is when there's a discussion brought up, that usually whoever makes the motion then is the first one to speak. And then usually what you try to do, and we all kind of know, if there's someone who is a opposing view, usually that's the next person, and you kind of go back and forth on that until everybody has had their one time to speak during that discussion after the motion is made. And then that's when we call for the vote. So everyone gets their chance to speak, and it should go back and forth so everybody does have a chance, if there is a motion made. If it's just discussion, it's just discussion. But if there's a motion made, it should go to the person who made the motion, outlined in here, and usually someone who you know is opposed. And then until everyone has their point or their opportunity to say something, and that's why I want to go through this again, because this kind of outlines that, and I didn't know until like partially through this year, just looking at that, yep, the person makes that motion, that's the first one. And then try to go to an opposing view so that you can, but then also then you get everybody else, and everyone should only really speak one time after that motion's made. That's the other thing, you get your information out quick, like responses maybe to a question, but then it really should be one time to give your, and then we vote. And that's kind of the one thing here, there's a call to vote, but it shouldn't just keep, we've had some that just keep kind of circling, it should just be one time really for everybody to give their stance, and then we vote. And again, that's in here as well.
I think we need to discuss this further at a later board meeting, the possibility of being able to get something on the agenda without discussion for the following meeting.
Well, the way we are doing it now, it actually gives us more opportunity to have an item added to the agenda because you have the entire amount of time between meetings. If we limit it to just,
I'm not saying limited, I'm saying it's an additional option to get it on the agenda. It wouldn't take the place of what we're doing now, it's just an additional option. But we can talk about it more.
To simply have it proposed and seconded at the end of a meeting for the next.
Right.
There's some
All you need is a
efficiency there.
second, right.
Well, we
So I
used to
think the
do it,
second-
we got rid of it for that specific reason.
Yeah,
I mean,
because then there
it didn't
was,
change for
there was
no
people
reason.
doing this, shaking their head, well, that's a,
Or arguing about it.
or, yeah, no, I don't wanna see that on there, and it just, you,
But having something on the agenda, I mean, we shouldn't try to prevent something being on the agenda. If it's important to a board member, then maybe it should be discussed. So,
Yeah, but there's laws that govern what we can discuss, that's the only problem.
yeah, I'm not talking about discussing it at that time, I'm just saying get it on the agenda. It's not open for discussion.
well, we have a process.
yep, we have our policy and
We do, but we can change it.
we can't.
Right.
Danny's referenced watching a lot of other board meetings. I've watched a few, and they've been very helpful. I'm like, wow, that's what I want to see. And
What is
just,
that?
Just
What do you see that they do different that we?
like the ability to just kind of propose things, and they're like, these are training board meetings where they're saying this is definitely not violating any open meeting laws or Robert's rules, and it's just done in that conversational, but obviously requires everyone to be respectful and to be very aware of the lines that shouldn't be crossed, and it can be very efficient and effective. I'm not saying it's easy, but maybe
Right.
something to strive for.
What can be, I don't know what you're talking about.
Discussing potential agenda items without breaking any of the open meeting laws.
But any discussion is a
It's a
violation.
violation of.
discussion.
Mentioning a topic and
Getting it on the agenda, asking for a second, getting it on the agenda. It's really that simple.
Anything else in here that anybody has thoughts on? Something was brought up, you know, when we do, maybe Trevor, you can weigh in, but when we do the vote for, you know, a unit, not a roll call vote, so we go through and do the, tonight we'll do a consent agenda. You know, we motion a second, we'll do the consent, and then say all in favor, aye, any opposed, any nothing. You know, we've done it where, I think you brought up where we've had, you know, aye, and you raise your hand, so that you know, like, yep, that person is part of that, because, you know, aye, and you don't hear anything, well, it's 7-0, but if someone doesn't say anything, is it, well, I didn't actually say anything at that meeting, but it's, do you want to show that? Is that something that should happen, or is it good practice, or?
I think practices are all over the board. I mean, every district does it slightly differently. There are some districts that everything is a roll call vote, just so there's never a question about it. There are other districts that if you can't quite tell and you're like, wait, who voted? I'm calling for a roll call, where that's just what a chair will do. Or, I mean, there are also lots of districts that it's always 7-0 on literally everything, so no one even has a question about it. But if you were the one that that either didn't vote or was abstaining and you just moved forward, you'd want to make sure that your vote was properly counted. That you want to say, hold on, like, I either want a roll call or I want it on the record that I abstained. And that's really kind of the obligation of each board member to make sure that their vote is counted correctly, because it's your vote.
Right, well, I just figured I'd throw this out at everybody, just for reference, or for a guide, or if anybody's ever wondering. After kind of working for a year, I thought it was something good that I'm gonna have next meeting or every meeting, just to think about, and
Good discussion.
all right, so again, thank you, Trevor, for coming.
Thank you.
Tonight.
See everybody.
See ya.
Enjoy the rest of your meeting.
All right, and with that, I will hand this off to Shannon.
Yep, so we will start with reorganization. So in front of you, you should have your ballot. Based off of our policy, there is not a spot to put your name, so these are secret, for lack of a better word. So we will start with the president, so I will start this process. Once the new president is voted, then the president will take over, and then the president will facilitate vice president, clerk, and treasurer. So at this point, I will take nominations for president for the Somerset School Board.
I will nominate Matt Foucault.
Okay,
I will nominate Bruce Largen for president.
I am disinclined to acquiesce to that request.
okay.
I'll nominate Ian McDonald.
I'm in the same boat Bruce is in. I can't remove the time. It wouldn't be fair to the district.
Okay, so far we have a nomination for Matt. Any other nominations?
I nominate Danny.
Last call, any other nominations for president? So in front of you, if you can circle president at the top and then circle the person that you are voting for. Alicia will walk around and pick them up, and then she and I will count them out loud over here. All right. So we have one vote for Danny. I'll just separate them this way. Yeah. One vote for Matt. A second vote for Matt. A third vote for Matt. A fourth vote for Matt. And a second vote for Danny. So based off of a 4-2 vote, Matt Foucault is the new school board president.
Are we missing one?
That was me. I just abstained.
Congratulations.
All right, I will hand it to you.
All right, I'll need some help here, so, while I get my feet wet.
As for nominations.
Yeah, I'll take nominations
Vice
for
president.
vice president.
I will nominate Bruce Largen for vice president.
Bruce, you good with that?
Yeah, I'll take that.
I'll nominate Corey Miller.
Corey, you good with that?
No, I'm too new.
Are you declining?
I'm declining, thank you.
Okay. So there's one motion for Bruce. Any other motions?
I'll nominate Danny.
Okay, are you good with that?
I'm good.
Okay, so I have a nomination for Bruce and a nomination for Danny. Any other nominations? Okay, please circle vice president and your choice. All right, one vote for Bruce, one vote for Danny, another vote for Bruce, a third vote for Bruce, a second for Danny, a fourth for Bruce, and a fifth for Bruce. So 5-2 for Bruce, vice president. All right, I'll take nominations for clerk.
I'll nominate Ian.
Ian, are you good with that? nomination for Ian. Any other nominations? Any other nominations? All right, hearing none, do we need to do a vote still?
Nope.
No, no vote. Ian, you are the new clerk, or the continued clerk. All right, I'll take nominations for treasurer.
I nominate Lori Larson.
Are you good at that?
Yes.
One for Lori. Any other nominations? Last call. All right, hearing none. Lori, treasurer.
Okay, thank you.
Superintendent report.
So a couple things tonight. I'd like you to start by looking at the memo under 7B, recommendation for a new licensed physician to serve as district medical advisor. So our previous advisor has been Dr. Jen Belil. She's done great work with the district. Some things have changed at her work regarding her coverage and malpractice. So she reached out to us and said, unfortunately, she wouldn't be able to do this any longer unless the district basically provided coverage for her, which at this point we weren't interested or needing to do. So we thank her for the work that she's done over the last couple years. Our nurse Autumn reached out and is recommending Dr. Stephen Harold. You can see a little bio there. This position is required by policy. Once a year, they will review certain policies just to make sure they're still in compliance. It's someone that our nurse specifically can reach out to if we have, any significant medical things happening in the district. They will sign off on some medication type things, like ensuring we have EpiPens, for example, in our office. So basically the word advisor is exactly what this person does, just someone that we can reach out to on a consistent basis that's familiar with our policies. And again, it's required that we have this person as a part of our policy as well. So first reading tonight does not need to be necessarily approved tonight. So Dr. Belil knows that we're in this process, and she's kind of officially our advisor for a few more weeks, but hoping after the next meeting we'll transition from her to Dr. Harold.
Our agenda does say that we can take action
Oh, that one does say
tonight.
that, yes, I'm sorry, you're right. I was
So
looking at the bottom one.
Would make a motion that
Yeah,
we do
yep.
because there's a state statute that says that we're required to have this
Yep.
as well. And since she's not covered to continue as our medical advisor, I think we should make that motion tonight. So I'm making a motion to appoint Dr. Harold as our medical advisor.
Okay.
Thank you. I was looking at the wrong one, so thank you. Yeah.
I'll second that.
So there's a motion and a second. Any discussion? No discussion. All in favor?
Aye.
Any opposed? Motion passes.
Perfect, thank you. So the second one under 7C does not need to be necessarily voted on tonight, but this is something that comes before the board every year. It is consulting for our E-rate services through CISA 9. So as a reminder, we are part of CISA 10. Sometimes other CISAs provide other services that CISA 11 does not necessarily provide. So we are going through CISA 9 to get E-rate, which is basically a whole bunch of reductions for a lot of our wireless infrastructure and all things IT. They really keep a close eye on ways that basically they can save districts money. So this memo is for a consulting fee of $1,885 through a shared services contract. Again, this is something that we've brought before the board annually for multiple years. IT worked closely with CISA 9, again, to make sure, as you can see, Jason Hamari put a little example here of just one way that we are saving a whole bunch of money by utilizing their consultation services. So if there's questions, I'm happy to answer it. Jason's probably going to be your best bet to be able to answer real specific questions, but this is something that can be brought back to the next meeting, does not have to be approved necessarily tonight.
So if they have questions, just email him and copy you.
Yes, that would be great. He works with this a much higher level than I do.
It
So.
says sign a return by May 15th.
Yep, so I reached out to them and told them that our second meeting was after that, and they said, no problem, go ahead and scan it to us after your second meeting.
Thank you.
Yep.
Okay.
So 7D, this one also indicates discussion, possible action. So this is coming before you to ask for 2 days of snow day forgiveness. And there's a couple layers here. So this year, I feel pretty confident that at this point moving forward, we won't have any more snow days, which is why it takes usually till this time of year before we bring something like this forward. But we had 2 snow days this year. And so we asked the board when this happens to essentially forgive those days for our teaching staff. Otherwise, the teaching staff have to make those 2 days up. So they would be here essentially 2 days longer at the end of the year. That typically has not been our practice in our district. Even a couple years ago, I remember bringing a memo, I think it was almost 4 days that we asked for forgiveness, the year that we had like 10 snow days, which was crazy. So it's essentially recognizing that we had 2 days that we called off school. Teachers were not working, those were not virtual learning days. And so those are 2 days contractually we just have to think about. Again, our practice typically has been bringing this before the board, and the board then has forgiven those days for staff where they wouldn't have to make them up past the current last day of the school year. This does not apply to administrators, so nothing we have to do there. You can see here that supervisory support staff would be the other group that we would need to consider. Based off of how their contracts run, these 2 days, we would actually add 2 additional vacation days onto the staff because that's, again, what we have in our handbook, and they run on a little bit different contract than teachers or administrators. And support staff, since our 2 snow days have been given multiple opportunities to come on our professional learning days to be able to make up that time, we've offered as well, and you can probably speak to this too, but even modules and some learning that they can do at home on those specific days. So really this memo is forgiving 2 days for teachers and adding 2 additional vacation days for supervisory support staff who come in on those days and they work on those days. Like they're here physically on campus on snow days, if that makes sense.
So for supervisory support staff who did report to work,
Yep.
they get an additional
Correct.
vacation.
Yep, thank you. Again, nothing for admin, and we feel confident about our plan that we've had for support staff, multiple ways for them to be able to make up that lost income on those 2 days. And some choose to take advantage and some don't, which is okay. We have another professional learning day coming up next Monday. There's the next opportunity if people want to come in. So it's really just teachers and supervisory support staff. So if you have questions, feel free to, as you can see, this came from myself. Rochelle obviously helps put this together too in HR, so we can help answer any questions in the next 2 weeks if things come up.
And this does not affect the required time for students.
Nope, so we build in added days to navigate required instructional hours. So as a reminder, students aren't bound by days, it's hours. So we intentionally add a few added days for instructional purposes for students, but that doesn't impact the 2 days for teachers. Yep, so we're good for instructional hours. We don't have to make anything up. If we would have had any additional days, we would have had to do some virtual days for middle school, high school in particular, but we skated just underneath the criteria. So we should be good there.
There's 2 days built in each calendar year typically.
What's that?
There's 2 extra days for students, so that anticipating 2 snow days, you're
It,
break even.
it varies depending on how the calendar lies. So sometimes 2 is typically our minimum. Depending on, right, how the start of the year starts, depending on, again, holidays can sometimes lay funny, right? So typically it's 2-ish days, 3 maybe. We don't like to go a whole much beyond that, but we've had years, like I said, my first year as superintendent, we had, I think it was 10 and a half or something snow days, right? We ended up doing virtual and things like that, but we try to plan as much as we can for at least a little bit of contingency, but then have to go to a plan B after that, so, yep. So that comes back. Nope.
Just come back, okay.
Yep, I'm sorry, this one does need action. Sorry, I'm getting all my memos mixed up. It would be preferable if there was action. If you need some more time, it's not the worst thing in the world, so if anybody around the table would like more time to learn more, ask some questions, we can certainly do that. If people feel prepared to make a motion and take action on it, that'd be great too.
I'll make a motion to forgive the 2 snow days.
Is there a second?
I'll second.
Second, Steve. Any discussion? No discussion? All in favor?
Aye.
Any opposed? All right, motion passes.
Perfect, thank you. So out of those 3 things, the CISA 9 shared service contract will be the one thing to come back for vote next meeting. And then the last thing I have was just to give a quick leadership cohort update. So at this point, we've had 4 meetings, which have been great. Topics have included kind of an overall state of the district, one specific meeting on school finance and budget, one meeting on student wellness, which was a lot of, it actually ended up being a follow-up to the board meeting we had, looking at our strategic plan with SEL and DEI, kind of talking about what we do there. Our last meeting was all things curriculum, and really kind of going through what is the process we use to adopt parents' rights, what does that look like, you know, how do we basically determine what we put in front of our kids, where does libraries come in, classroom books, all that kind of stuff, which was great. In our last meeting, we're going to talk about technology and have some discussions about cell phones and AI, and you know, an hour and a half goes very, very quickly. If I had one thing to change, I would have probably extended the time at least by a little bit because it goes so fast. Lots of good discussion, really good feedback. I take feedback from everyone that's there after every meeting and then use that to kind of help outline how the structure will work for the next meeting, which has been great. So I have asked for a few volunteers to come in June and have the people that were directly in that cohort provide an update for, basically I kind of left it open of whatever you think would be helpful for the board to know or hear or learn about your experience would be great. I'm not providing them any sort of a framework or you must talk about this or that. I think it's good just to hear from, you know, over 20 people that showed up, you know, for soon to be 5 meetings on, you know, Wednesday mornings just to have some really good conversation. I would imagine you will hear from them that, you know, there's people walking out of that room learning things about the district that frankly they just didn't know. And it's a wide variety of parents and community members and people that have kids in the district now or people that used to have kids in the district. So whether this continues, obviously that's not in my purview anymore, but I've been thankful for the people that have showed up and engaged in some really good discussion. I've had 3 student meetings for this cohort as well. Really had a good opportunity to sit down and talk with a wide variety of kids, get some good feedback about what's going well and some things they'd like to see done differently, which is always, the student voice obviously is really powerful. So just with crazy scheduling and spring sports and graduation, I'm not sure we're gonna be able to get another meeting on the books, but I've been thankful to at least have that contact with the students. So I said in June, I don't know if it'll be the first or second meeting, but I do have some people that have said, yeah, I'll come and talk at the board meeting, so stay tuned for an update from the group.
Excellent, thank you. Jesse, ES3 grant.
Okay. Thank you. Okay, well, I'm gonna chat for just a little bit about the ES3 grant. The ES3 stands for Enhancing Social Emotional Skills for Students with IEPs. So just give you guys a little bit of additional information. It's been in some of my updates. Part of the grant requirement is that I just keep you guys informed of kind of what the grant is. This is our first year with it. It's a discretionary grant. It's funded under IDEA. So the previous Pupil Service Director, Abby Bahada, had applied for it and was awarded it this summer. So the planning kind of started before I even took my position. The goal of the grant is really to provide districts just to make sure that we have the structures in place, different processes to identify kind of what we're doing, what's working, what's not working, looking at all of our staff, so our teaching staff, paraprofessionals, any other support staff, kind of look at what the beliefs are, what skills do they have, and what systems do we have in place to improve the student outcomes for those students that are identified with the disabilities or have the individualized education programs. So our district is supported by statewide coordinators. We have 2, Teresa Haas and Katie Berg, and they've worked with the teams. I'll tell you a little bit about the teams as well, but they provide coaching, they provide additional training, and they're just like a wealth of knowledge and resources that they've been sharing with us, so it's really awesome that we get this opportunity. The whole goal of it is really to look at evidence-based strategies for students that have identified disabilities. And so we are focused on 3 different students right now, and we're implementing these evidence-based strategies to try to improve their outcomes, kind of district-wide. So all staff that work with these students, how can we gain some knowledge, how can we gain some skills? And like I said before, it's only for students that have identified disabilities, right? That's our target group. So students that have autism, the emotional behavioral disability, or other health impairment. They also might be students that maybe have a learning disability, but maybe they struggle with some social, emotional, some regulation skills, so it might be identified as a disability area related need, so we can also target those students as well. So lots of different layers of the team. I'm the district coordinator. Then we have 2 internal coaches, so Kristen Kraft at the high school and Kylie Fader at the middle school. The internal coaches are really just kind of there to help kind of work with the implementation team for the students that we are targeting, if that makes sense. It'll continue to grow each year. The core team is just kind of a team that comes together once a month. We do these trainings, we sit in these 2-hour workshops with Risa and Katie and all of the other districts across the state that are a part of this grant. And we work on different skills, we learn different tools, we kind of gain some knowledge. The implementation team, we've just kind of started to dip our toes in right now. An implementation team will be basically the students that we identified, so these 3 different students, pretty much their IEP team. So parents can be involved, paraprofessionals, general education teachers, special education teachers, and those implementation teams will work with the internal coaches, right, to get some of these evidence-based strategies kind of off the ground and running. The implementation teams will be we'll be diving in more in depth in the next 2 years. So these are the requirements. You guys have kind of touched on it a little bit. So we select different evidence-based improvement strategies that are going to match the student needs for how we want to improve their outcomes. One of the big outcomes that we're looking at, a big piece of that data, is looking at reducing our seclusion and restraints. So we have to report that to the board every year for both students with IEPs, without IEPs. So it's a really tangible piece of evidence of if we are improving the skills of all of our staff to work with these students that have some neurodivergent tendencies, then hopefully we will reduce those incidents of seclusion and restraint. So in January, we had root cause analysis meetings. So that whole implementation team sat around, we brought paras in, we brought general education teachers in, and kind of went through a whole process with the state coordinators. The staff found it really, really helpful because we really kind of dug into the nitty-gritty of what we're seeing, what behaviors are challenging, and then targeting what evidence-based strategy we wanted to use with those students. So it was a really awesome experience. Again, kind of working with the teams to make sure we have those, fine-tune our systems, increase the skills, and really increase and build on those coaching capabilities. We've attended different workshops, participated in different professional learning, really just, again, looking at our process and procedures for that data analysis, kind of the different decision-making and the coaching cycles. The funding for this lasts 3 years. So the first year is kind of the largest chunk of money. Next year it's a little less, so the third year a little less because it's trying to build in some capacity for us, right? Kind of building in some of these skills that we have for our internal coaches and kind of continue to grow that. This is what we spent the money on so far this year. So we had 6 staff members, including myself. We went to Impactful Coaching Academy, so it was 4 different sessions down in Sun Prairie with Tammy Gibbons. It was amazing. Again, just kind of growing those skills and capacity. We brought in Kate Swenson. She came and met with the special ed staff before I started, but it was, they just, after meeting with the special ed staff, that staff said like all staff need to hear kind of this message. So we brought her back at the January professional development, just again, kind of raising awareness to all staff that work with some of these students that have those disabilities. We purchased some books that the core team is kind of really diving into. Arise, the Art of Transformational Coaching, and the CERTS model. CERTS model is one of those evidence-based strategies to kind of implement for students that have autism. It's a great tool. We paid for subs when we've had to attend some of these training, food, lodging, kind of all of those pieces. Paid for paras to attend different trainings at CISA, and then also paid paras to come in on different professional development days so they can be a part of that root cause analysis. And like Shannon was saying, we're also offering another opportunity for all support staff to come in on May 12th to kind of work on some more of those inclusive strategies. So that is what we've done so far. We will, every year, they'll kind of get a little bit deeper. Every year I'll have to come back and kind of give you guys an update. Year 3, it ends with a video, and there'll be different testimonials, different video clips of the students that we're working with, and it'll be kind of like a fun project to see how far we've come over the last 3 years. Any questions for me?
I'm curious about the video, how
Yeah.
does that not violate student confidentiality?
It's a great question. I mean, I think we'll have to give parent permission. And it's really, again, so a lot of these evidence-based strategies, it's kind of happening day-to-day in the classroom. I'm not really sure. I mean, I think some of it is like, it'll be parent testimonials, it'll be staff testimonials. If there's some, with parent permission, if we can get some, snips of some really positive social interactions with peers. Because we're not going to identify which students are specifically targeted for, like, with their IEP. Is that what you're asking?
Well, kind of, yeah.
Yeah, no, I mean, I think it's just kind of globally what the impact that we're seeing. But I'm learning as I'm going, so I'll find out more year 3.
Thank you.
Anything else?
I have a question. I dug into this a little bit and it sounded like there was only like 4 of these given out per state. Does that sound right?
No.
No, okay, there's more of them.
Yeah, I mean, like I said, those monthly meetings that we have, I think there's probably 11 or 12 different districts on those calls.
Okay.
So that's just our little region, so.
How much was the grant for?
Great question. So this first year, we were allotted $24,000. Second year is $20,000, and the third year is $12,000. As long as we're meeting the deliverables of each year, then we'll continue to qualify for that.
Anything else?
Where do you recommend learning more about this, just to read up on it?
Yeah, they have a whole ES3 grant like site, so there's different resources, different on DPI. There's different testimonials. They have their whole separate webpage if you just search the ES3 grant.
Sounds good, thanks.
Yep.
All right, next item, the social school Ford EDU contract proposal. We had a presentation last meeting from this organization. Anybody wants to start the conversation?
Well, Andrea had mentioned that she had written a book about this, and it's available at the Somerset Library, except it's not right now because I haven't checked out. But, I just think this is a huge asset. It could be a huge asset to our district, something very valuable to point out the positives. We have so much going on in our district to be proud of, and people don't always hear about the good things, and it's our responsibility to make sure that we share that information. So I'm excited about, I hope the board approves this contract.
Do you have any opinion on which option, the 1 or the 3?
Well, the 3-year is more cost effective.
I don't think we're in the position to spend this money right now. And it doesn't directly relate to student achievement for me either. I mean, it makes us feel good, and if money grew on trees, I would love to spend it on this, but I just don't think we have it.
I think we need to defer this cost. We've got a new superintendent coming in, they might have a different opinion on this topic. I also think this is money we could spend towards SRO training, so I'm not in favor of spending money on PR.
It was a nice presentation. I'm curious if there's any benchmarking. Are there other options, something? I mean, it's one of those things where you hear about something, ooh, great, never don't know anything about it, didn't know it was done before. Let's sign a 3-year contract with the first time I've ever heard of it. Maybe, are there others to look into? Maybe just table it. I'm also not comfortable spending money right now.
So we give 1 year, I think it was $11,000, or $11,500. I know where we are budget-wise, and we don't really know. I would say that I think our current superintendent does a lot on our website, and I'm not sure how much is going to be done by our next superintendent, just kind of add to their plate. So not that I wanna spend the money, but I think trying it out for 1 year and getting feedback before we signed up any further, I mean, for $11,000 and we have money, saved up. I guess the way I look at it is, we have a fund balance of 21% or something of our yearly, which is, we're supposed to be in that 15 to 25 or something. I think we're around 21 or so percent. To me, this is a one-time cost there. We try it and see, and then we'll know next year what our budget gets from the state and if we want to continue. But I think it wouldn't hurt to try it for a year and get feedback from staff and community if it's something they want to keep spending money on, and if not, after seeing what it does, we pull back, like she said, they did it in Osceola, and then they didn't do it in Osceola.
Well, they continued, they had somebody who took it on, who was on staff, but one of the other contracts that you can sign is to have support from Andrea. So they had as one of their internal employees' job responsibilities was to keep doing the posting. And so instead of the messages from staff going to Andrea or one of her staff, they went to one of Osceola's staff members. And it was after it had been implemented with Andrea's company doing the work that one of their employees felt comfortable taking that on, and that employee left. And so they were seamlessly able to move back in with the social school for EDU company taking that over again.
Well, I'll make a motion to approve a 1 year, option 1 year commitment for social school for EDU contract.
I'll second.
Okay, there's a motion and a second. Any discussion? I know there's been some discussion. Ian, did you want to say something?
No, I mean, I'm interested in see what it does, but I would be more in favor of a 1 year and see what happens versus.
Yeah, I was in the same boat. I was in favor of a 1 year. I'd like to see, so when you talk about benchmarks, I mean, it's all going to be in, we're going to see it in Facebook and the social world. I mean, we'll see either we're going to drive up our viewers or not. So I think in terms of transparency, in terms of community engagement, like this is a perfect opportunity, coming from the public sector world, community engagement and reaching the people that live here or want to come here. Like this is super important. I am in favor of the 1 year because I want to see, do we have results? I don't want to do a 3 year. But I think it's valuable. I don't think it should fall on a staff member to do. And the last thing I want to say is I was watching the post from, about the principals. So we have almost 4,000 followers on Facebook, the district does, and the last I checked a couple days ago, there was like 140 likes on that post. So that should have gotten thousands of people engaging with that post. So this is just a perfect opportunity to try something different. And if it doesn't, we can always go back.
And she gives quarterly reports.
Yeah, and that was where I was going, like, we'll know halfway through the year, she says yes, and staff and community, are we getting involvement, are we posting the right things? I think there's a lot of feedback from her.
What if we get a superintendent who does this really well? Would there be a reason to wait until we do some interviewing? I mean, Shannon does a great job, I really appreciate that. Maybe other people have that skill too.
I don't think there's any problem waiting. We're only talking about a month and a half before we make a move like that. It's kind of a big move, PR, to do this and spend that money before the superintendent comes in.
Okay, well, there's a motion and a second. So if there's no further discussion, we'll take a vote.
We should take a roll call vote.
Sure, we can take a roll call vote. Any further discussion first? All right, Steve, we'll start with you.
No.
No.
Yes.
Lori?
Yes.
Bruce?
Yes.
Okay.
No.
And me, yes. Motion passes 4-3. Okay, so you,
What I was gonna say, what I can do then, I told her I would connect with her one way or the other tomorrow after this meeting. So I think I'm hearing, I will let her know we're moving forward with a 1-year commitment. I think she put it on here too, it indicated that her goal would be to get it up and running by the 15th. She thought that might be tight, but she was gonna obviously try to get it going as soon as possible. I don't know what that means, you know, she talked a little bit about rolling it out with staff, there's some training that has to happen for people to know where do I sign, all the stuff, right? I'm sure she'll take care of that, but I will connect with her tomorrow.
And the contract is attached, so
Yep.
we can print that out and sign it.
next item, we got to appoint some members to a few different committees. So the first one is the policy committee. Currently it's Danny, Lori, Ian, is that correct? Do we do the same process for nominations? How do we run this? How do we appoint these? Can you remind me, Bruce or Lori?
I think we asked if anybody wanted to be on.
Yeah, so I would start with, is anybody interested? And then if there happens to be more than one person, then you would have to go through the process of voting.
Okay. And we have up to 3, correct?
Yes.
Okay. Is there anyone interested in the policy committee to start with?
I'm interested.
Danny?
So am I.
Lori?
I've been on it for, ever since I've been on the school board, so going on 8 years now.
Okay, there's 2. We can have one more, but we'll take nominations if there's more interested. Anyone else interested in?
Nominate Corey.
Corey, would you like to be on the policy committee?
We had 2.
I think you guys have it really well covered. I am very into learning all of them and diving deep into it. I think if there's someone else that already has a head start on me, they're gonna add more value. But definitely maybe next year.
We've
Ian,
had
do you want to
2.
continue?
We've had 2 before.
Ian, are your job responsibilities such that it makes it difficult for you to continue?
It depends on when the meetings occur. During the days,
Yeah.
if we're doing evenings, then no problem. Clerk stuff is easy because I have Alicia.
Unfortunately,
I mean, if the board really wants me to, I will do it.
the meetings pretty much have to occur during the school day because we have a Neola representative who comes, and Alicia takes care of all the she's the one who works with the documents and sends them back and forth. So it is a time commitment, and it does interfere with what they, you're absolutely right.
How many meetings a year and can they be virtual?
I've done them virtually.
Not so good.
It's a challenge.
Well, we can have
They're
2,
hours.
correct?
Usually hours long.
Yeah, they are long.
Do we move forward with 2 of you?
It's all right with me.
Do you guys
Okay.
need more help? Or is 2 okay?
I'm fine.
And depending on what the policy is, we often reach out to administrators. For example, if it's something that has to do with health policy, we will involve the school nurse and perhaps the medical advisor as well. So depending on the policy, we often ask for input from the administrators or employees who are involved.
And you guys pull together the Google Doc
Yep.
that we all look at and review with all the cross-outs.
Just because you're not on the committee doesn't mean you don't
Yes.
have input, so.
Yeah.
Oh, yeah, and we don't decide anything, we make recommendations, but the board votes on everything.
Okay, we'll continue with the 2 of you then for this year. Thank you
guys.
to both of you. Okay, next one is a delegate for CISA 11 convention. It'll be on June 2nd of this year. Who attended last year?
Well, it's more than just the convention, it's being
The delegate?
the board member to the CISA
Okay.
11, and so I've been that delegate, so I've been on the CISA board for several years. And
You're on
I'm
it.
willing to continue that unless somebody else would like to take that over.
Is there anybody interested?
I'll let Lori do it.
Okay, last opportunity. Anybody else interested? All right, Lori, it's yours. And then WASB delegate.
We've done that one, we haven't done.
I'd recommend postponing this until November or December because it's going to depend on who is available to attend the convention.
Okay. So we did not have a delegate.
Appointed ahead of time. We appointed one prior to leaving.
Yeah.
Oh, because the two of you went to the meeting, right?
Right.
Okay. Okay, so we will postpone that one. And then Somerset Memorial Scholarship Representative. Do we have one member or two? Is this typically just one board representative?
The Somerset Memorial Scholarship Fund requires in their bylaws that there is at least one school board representative.
Okay, and that was you
It
last
has
year?
been,
Lacey.
Lacey did it for a time.
What does that entail?
It entails going to monthly meetings. Pam Powers is our current president. She runs a very good meeting. They're from 5:30 to 6:30, the first Wednesday of the month. The other thing it requires, though, is you are required to evaluate every scholarship application and score them. You also need to, the main fundraiser for the scholarship fund is selling 50/50 tickets and taking tickets at home events. So you would also be required to attend and take tickets and sell 50/50 tickets at home events.
Bruce, are you interested?
Yeah, I'd love, yeah. Let's do this thing.
Okay.
Yeah, I didn't sign up for the other stuff. I gotta go to more events. Oh, darn,
Anyone else interested?
You can watch the basketball game after halftime.
I'd rather watch it on my live stream anyway.
Anyone else? Are you okay not being it?
Oh, I can still be on the committee, I just won't be the board representative.
Okay, perfect. Okay, Bruce, it's you.
Yes.
All right, next item, consent agenda. Is there a motion to approve as presented?
I'll make a motion to approve the personnel update in A1 and 2.
Is there a second?
A second.
Any discussion?
Yeah, I have some discussion. I would like to, talk about not posting for the Director of Business Services and Operations position at this time, so that we could get some input from CISA about if they can cover this position for us, if we can share this position. And I'd also like to get some recommendations, someone to come in who knows this position. I understand CISA already has people that they share with other school districts, and I'd like to get some input from them on where we are in our business office, and any recommendations they might have.
Okay. What does that mean for operations for you?
I don't know. You guys tell me.
Dave's on through you.
Yeah, he's here through June.
Okay.
I guess I would suggest getting some information from Dave and the business office, so the board has a full understanding of what exactly his job is as a part of all of that. CISA does have a service where they will come in and do basically an audit. I don't know if that's exactly what you're talking about, but they do offer that, that you could look into. I will go on record saying it would not be my recommendation. I get it doesn't matter at this point, but the size of our district and the complexity of what happens in that office, I would not recommend sharing, but I'll get whatever you tell me to get.
Okay, so when you say they will do an audit of our operations? Is that what you're talking about?
Basically, the people that we have in the business office, and basically give kind of independent examination of, are you overstaffed, are you understaffed, those kinds of things. So
Do we
I
pay
talked
for
to
that?
Brandon, yeah, yep. It's a service basically they provide, right? I talked to Brandon as well just to see what some of the options are, because the timing is hard. Obviously, the later we wait to post it, it gets hard. A new superintendent coming in, this is a big piece of information. I would ensure that you share with the people applying, because someone coming in, again, a district this size, potentially not having a full-time person in this position, that would be a really important piece of information to share with people applying. So,
Can somebody from or from CISA come and give us a presentation on what they could do? Is that what you're saying? Do they do that?
They could, yeah.
I mean, I guess I'd like to hear from them what they would do if it was shared service. Can you reach out to them?
yeah,
And see if they can come and give a quick presentation?
sure.
At our next meeting.
Yeah. Yeah, I would, I mean, I just echo, I would.
Is there information that you can just share with the board, via email or something?
You could, I think it's fairly cut and dry. I'm sure he's got things that are easily emailable, like this is literally what we do, right? And again, I think it's putting all those pieces together of how does our business office function, which, you know, in every district you look at, it's different depending on what do you contract, what do you have in how, I mean, all the things. So I think it's also equally as important that all of you get a full understanding of what happens there day to day with the people that we have, who does what. Certainly in, you know, in tandem to all of these things, of course, of what can CISA do. I can tell you in talking to Brandon, because I asked him this question flat out, like, do you see districts our size typically having shared or part-time? And he said, no, typically districts this size, CISA would come in and help with like an interim if you had trouble finding someone, which also is a concern that I'd like to share publicly. These positions are very difficult to fill. So he said we have people that could help, you know, certainly in an interim basis, but again, his suggestion was not necessarily part-time. His opinion, knowing our district and again, knowing our size, that would be hard having a half-time, but worth looking into, of course. Now's kind of the time to do it, right? So.
Okay, yeah, if they can come and give a presentation or just email, whatever it is. And
Yeah,
I
I'll
would-
ask him, yep. I'll
I would
see what-
encourage all of you guys to reach out to Dave in the next 2 weeks, have a conversation to understand on your own what his office does. So
Well,
when we come to the meeting,
that would take, I mean, if he's answering questions individually from 7 people,
Yeah.
perhaps what we'd rather have, and, you know, please add Shannon, we have on paper a job description.
Yep.
And perhaps we should have the job description for each member of the business department, so that we can see overall how many positions we have and what each of them is responsible for. What do you think about that?
Yep. I think, so I get what you're saying. I think something a little more streamlined is probably gonna be more helpful of, you know, we can gather information, send it all to you at the same time, so you're all getting the same information. Then from there, I would say if you have questions, certainly reach out to Dave or myself or whoever, but I think that's a crucial component, because I think there's a lot of assumptions that get made about what happens here every day, and unless you're here living it or running the school district, I think it's hard to really know the ins and outs of what he does and what everybody else does that sits out there, and how that looks different from other districts, right? So, not good or bad, we're just, everyone's set up a little bit different, so, yeah, we'll put something together and we'll get it sent out for sure. Yeah.
And we'll get some information from CISA as well.
So I think 2 things. One, I gather internally, it sounds like you want some information about what happens out here. That's part 1. And then I will connect with Brandon and have him send me kind of what's the menu of options of with this position, what can CISA offer. So 2 things that I will send you.
Okay.
Make
Yeah,
sense?
I just think, I hear what you're saying about the next superintendent and the hiring that, and letting them know this is where we sit. I'm wondering, after that first meeting, we'll have interviews with that group around the 19th and the 20th as a question of, do we post for this position now and have it hired through our current superintendent, or do we do an interim type thing with CISA to the end of the year, and then they hire that person, or we post, I don't know, just something to discuss.
outside of CSEP? So what other options is somewhat typical for a district our size?
I'm not aware. Districts our size have people internal doing the job.
All
So,
this?
Are there options? Probably. I just wouldn't be able to tell you what those are.
But your recommendation was like, they were so close, probably better to have somebody that's really inside and involved, rather than outside. That's-
My recommendation is to fill Dave's position as is, but,
Okay.
yeah.
Okay, so do we bring this back to the next agenda for discussion? Because by that point, we will have information on job descriptions and from CISA. Okay. Okay, any further discussion? All right, all in favor?
Aye.
Any opposed? All right, motion passes. Next item, general information, May 15th, will be a closed session. HYO will be here to present the superintendent profile and their slate review. May 19th is also a closed session. It'll be our first round interviews for superintendent. May 19th is also a regular session meeting. There'll be no listening session prior. And Bruce, can you remind me, we are starting that regular meeting, what time are we starting at? 4? Okay, so that regular meeting
Session
is
on May 19th is
4 p.m.
Yeah.
Okay. May 20th is another closed session. It'll be day 2 of interviews. Okay. I was more concerned about that regular session just for agenda purposes. May 27th is another closed session. It'll be final round superintendent interviews. May 28th, closed session. We will move to open session to announce a hiring decision. District celebrations. Steve, start with you.
I'll pass.
Okay. Corey.
Glad to be here, enjoying getting to know all of you, and looking forward to great things.
Ian?
Wish the teachers and staffs a happy Teacher and Staff Appreciation Week. Make sure, if you haven't already, to fill out the survey on the superintendent at 8th. I think there's one more focus group on Wednesday.
But that's just for staff.
Is that just for
Yeah,
staff?
there were 2 community ones. One was in person and one was virtual on Sunday. I mean, that's how it's listed.
There's another community virtual on Wednesday.
On Wednesday?
And-
If it's not on our websites.
Okay, because I thought when I looked, it said it was for staff.
And I just listened to the virtual meeting last night, and there was only one person. So
Just one attendee.
please, people, come to those.
It's too nice out.
And fill out the online survey.
Anything else? Lori?
You know, the Educator Appreciation Week, thank you to all of our staff who do amazing things with our students every single day. The online survey that Ian already mentioned. Thursday, May 8th is Bike to School Day. They encourage parents to participate as well. Saturday, May 10th, from 9:30 to 10:30 a.m. There's an event at the elementary school having to do with Earth Day, where they're going to be planting flowers, spreading mulch, and working in the garden. They encourage people to bring gloves and a small trowel or rake and an adult. And I'd just like to thank Dr. Belil for her years of service to the district. It was a pleasure working with her regarding the school district policies connected to the health and well-being of our students and staff. And I always found her advice to be extremely prompt, professional, and valuable.
Thank you. Bruce?
Make sure you check our website for the band concert, choir concert in the middle school, and a choir concert that's coming up later this month. There's a lot of like end of the year events going on at the elementary school, like for each class with their end of the year concerts.
Grandparents' Day.
And thanks Dave 2011,
14 years.
14 years, so thank you, Dave, for being here that long and answering all the questions that all of us have. We're reviewing the budget with us every year. And spring, it's nice out, there's a lot of events going on outside. Baseball is home today, there's a few more games this week, there's a game this weekend on Saturday as well, and buy something from concessions when you're there to help support the middle schoolers on their trip to Washington DC.
Great, thanks. Dan?
I don't have anything else.
All right, I don't either, everything was taken already and said, so I have nothing else. I will take a motion to adjourn into closed session. There's two reasons. The first one is pursuant to Wisconsin Statute 19.85, paragraph 1C, for the consideration of employment, promotion, compensation, or performance evaluation data of any public employee over which the governmental body has jurisdiction or exercises responsibility, as well as to move into closed session of the board pursuant to Wisconsin Statute Section 19.851F to consider the financial, medical, social, or personal histories or disciplinary data of specific persons which, if discussed in public, would be likely to have a substantial adverse effect upon the reputation of any person referred to in such histories or data. Is there a motion?
I'll make that motion.
Bruce? Is there a second?
Second.
And a second.
Okay.
Yeah, Corey. All in favor? Oh, sorry, any discussion?
No, we got a roll call.
No discussion? Aye, roll call. Steve?
Yes.
Corey?
Yes.
Ian?
Yes.
Lori?
Yes.
Bruce?
Yes.
Danny?
Yes.
And myself, yes. We are in closed session at 7:36.